Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, March 3rd. We have 11 bills on the docket. We're going to start off with Senator Carter with Senate Bill 691. We'll then move to 785, 684, 701, 837, 731, 875, 653, 769, 886, and we'll end up with Senator Huff with Senate Bill 703. But right now, we'll start off with Senator Carter with Senate Bill 691. Senator Carter, the floor is yours.
Thanks, Mr. Chair and members of the committee. I'm so pleased to be first up to present this bill. Mr. Chairman, I am so excited to present this bill. We've talked a lot about public safety, and I consider this yet another measure among our other public safety bills. I also want to thank Secretary Abbott and Betsy Tolentino, Jenny Egan, and all of the members of the Juvenile Justice Reform Council for working so vigilantly over the last 2 years to come up with our recommendations. This is the second time that we have heard this bill. It's my understanding that the cross-file of this bill that came out of the Juvenile Justice Reform recommendations has already passed the House. So with that, what this bill does is, as I just said, it derives from recommendations made by the bipartisan Juvenile Justice Reform Council in its January 2021 report. The bill does four main things. It bans the incarceration of youth for first-time misdemeanor offenses. It establishes a minimum age for juvenile court jurisdiction. It sets developmentally appropriate timeframes for probation and eliminates barriers to diversion. In 2020, as I've said many times, Human Rights for Kids ranked Maryland among the worst states in the country for its treatment of children in the criminal legal system. Prior to the pandemic, 2/3 of children incarcerated in Maryland's juvenile facilities were there for committing a misdemeanor offense or a technical violation. What is worse, Maryland law still criminalizes elementary school and middle school children. In fiscal year 2020, approximately 1,500 delinquency complaints were filed against children under the age of 13. Of them, 71.5% of those children were Black children. Young people need swift and certain responses to bad behavior, but the response must be calibrated to be the right dosage and intensity for the individual child. The Juvenile Justice Reform Council learned that providing more intervention than needed or providing services too late can backfire. For example, removing a child from their home for a low-level offense can cause new trauma and can increase rather than decrease the probability of criminality in that child. To address this, Senate Bill 691 bans incarceration for first-time misdemeanors that do not involve a gun, which would allow the state to focus on those who commit more serious offenses. Senate Bill 691 would also limit the circumstances under which a child younger than the age of 13 is subject to the jurisdiction of the juvenile court. Children are different than adults. Despite this obvious truth, in our juvenile justice system, they are treated as if they are small adults. Research shows that children are significantly less likely to comprehend legal proceedings and charges against them. How can we place children behind bars who are not yet allowed to be at home by themselves? By establishing a minimum age of incarceration, we can work toward rehabilitating children and preventing the physical and emotional trauma that incarceration may cause. Currently, juvenile probation is indefinite. Senate Bill 691 would set developmentally appropriate timeframes for probation. The evidence suggests that prolonging supervision for children has little efficacy. In order for a child to be successful, they need goals and timelines to work toward. With our current system, the risk for children to reoffend is higher. This bill will allow children, young people, to be held accountable in developmentally appropriate ways and keep those kids who have low-level first-time offenses from being pulled deeper into the system. Senate Bill 691 also aims to eliminate barriers to diversion. While children need help, there are ways to help them that are developmentally appropriate. Systems like the Department of Mental Health Services or schools can address young children's misbehavior. The bill would create a model for diversion policy and fund diversion programs across the state. In so doing, we will reduce recidivism and truly ensure that children are rehabilitated. Juvenile court was never intended to mediate schoolyard squabbles or mete out punishment for childish mistakes. Passing these common sense measures will shrink the juvenile justice system and allow the Department of Juvenile Services to focus its attention on providing evidence-based treatment to the most serious offenders and older youth who are at the greatest risk of committing violence instead of warehousing low-level offenders. It is time for Maryland's juvenile justice system to focus more on care, not cages. For those reasons, I urge this committee to give a favorable report. I'm happy to take questions, but I would also reiterate to the, or I should have brought my panel up, Mr. Chairman. If I would like to bring up Secretary Abbott and the panel for this bill. The reason being, you may have questions, and I may be able to answer them, but they may be more suited toward the secretary or someone else. So.
Absolutely, Senator Carter. So what we'll do is we'll bring up your sponsor panel. So we'll have the secretary come up, and is Ms. Egan here? All right, we got it. And then Mr. Schindler, you're on the sponsor panel as well. And then Keisha Hogan.
Mr. Chairman, also, I may need to be excused because I have another bill in finance.
No, we understand. Yes, thank you very much, Senator Carter. All right, we'll start off then with Secretary Abbott.
Thank you, Mr. Chairman. Members of the committee, Sam Abbott, Secretary for the Department of Juvenile Services, and I'm here in support of Senate Bill 691 because it's good public policy. It was developed by a diverse, bipartisan, and well-informed council of experts, and because DJS is ready and able to implement it. Ms. Tolentino and I briefed this committee on January 27th. There are a number of talented advocates signed up. They can dive into the details, but I do want to go into sort of what went into this package here. You get bills from many different directions here. Sometimes they're done by advocates, by lobbyists, and some of them are departmentals. But this bill came, I think, in the best possible way. We started by listening. We conducted listening sessions across the state to hear from all sides of these issues. We had objective outside experts from Vera Institute evaluate and present the critical data points as directed by the council. And perhaps most importantly, we had council membership from across the spectrum, leaders from education, child-serving agencies, the judiciary, national and local juvenile justice experts, law enforcement, youth who have experienced our system, prosecutors, defender, victim rights, and of course you legislators that served on the council. And I want to specifically thank Mr. Chairman, you, Senator Carter, our bill sponsor, Senator West from this committee, and we had other senators as well, and members of the House that provided guidance and your dedicated service to making sure that we have a good bill to present to you. It was an honor to serve as chair of this highly esteemed group because it was such an incredible group, and because what came out in the end is a set of recommendations that are well thought out, rigorously analyzed, and fully supported by objective data. And even though we had such a diverse council, we had 36 total participants on that council, we arrived at these recommendations by consensus. The votes for these recommendations were nearly unanimous. And I think this is the best way to develop public policy, and I urge you to support this bill with a favorable report.
And we'll take questions at the end of the panel. So.
Thank you.
So Ms. Egan.
Thank you, Chair. Members of the committee, thank you for having us today, and thank you for having me. There are many parts of this bill. It's a big juvenile justice bill, and I'm going to just not go over all the things that the JJRC did or the ways that we built consensus. I want to talk specifically about probation and what positive youth development means in a juvenile rehabilitative setting or in juvenile court. Probation is a way of helping kids comply their behavior and provide the support services that they need to make sure that they desist from any delinquent behavior. So far, hi, this is Ms. Hogan. Right now, all juvenile probation is indefinite. I don't know if you've ever had a teenager, but if you've ever tried to ground a teenager or give them a consequence that's indefinite, it's a surefire way to have it backfire. Kids need concrete, finite time periods that they can set goals for which they can have incremental ways to achieve those goals. What we know about youth probation and positive youth development is setting incentives is often way more effective than setting consequences. If you incentivize compliance, if you incentivize kids to be able to behave and to work well together, they can do that. We have to be able to set limits for probation that kids can conceive of. I want to remind you that every 14-year-old alive today was born in 2008. When you talk about 6 months, 9 months, or 12 months of a child's life and a teenager's life, it represents a huge portion of their living memory. When you put a child on probation for 2 or 3 years, when they are only 14 or 15, it starts to constitute a majority of their life. That's why we have these developmentally appropriate limits. And I want to remind everyone, if the child were to have a new offense or to come back to court on a new matter, they would have the ability to go on a longer and a more extended probation. If a child has desisted from delinquent behavior, probation limits allow them to move forward positively and to get the kudos of reaching and meeting a goal. Thank you.
Yeah, so I have, Ms. Hogan is next on the list, so if you'd like to go.
Hi, everybody. Thank you very, very much for allowing me to be here to share my story. I am truly honored to be able to sit with decision makers who are able to make change. My son, Michael Parkerton Jr., at the age of 13, was sentenced to 891 days by Judge Herman C. Dawson in Prince George's County. Against all recommendations from every entity that interviewed him to send him home, he continued to have him committed for, again, I'm going to say this number, 891 days. So during that time period, I lost my complete mind. I have a family, I have 4 children in total. My son Michael is my firstborn, so we shared a special bond, and I lost it. I could not function. I couldn't care for my other children. I was in counseling twice a week. I lost my ability to be for a good 2 years of that time. During that time, my son was sent all over the state of Maryland. I had to witness my son being chemically restrained. I had to witness my son being malnourished. He lost at least 50 pounds. I suffered hardships trying to maintain visitation with my son. My son ultimately, by divine intervention, was sent home by another judge. It was not Judge Herman C. Dawson. It was another judge. Judge Dawson happened to go on vacation when my son went for a review, and I was finally able to speak in court on my son's behalf. I was never allowed to speak on my son's behalf in court. I want to note that my son, prior to this incident, had never been involved in any kind of criminal activity. So me going through this situation decimated me and changed me for life. I lost time that I will never get back. Never. I will never get that time back. I lost time with my other kids that I'm so resentful for because I was mentally caught up in trying to figure out how do I fight to get my son home, only to be faced with a new situation because when he was released, I was not able to set up any type of treatment plan for him until he came home, which is too late. I urge you guys to pass this bill. Having kids sentenced to 891 days is not only detrimental to the child, it's detrimental to the family as well. My son was out for 1 year and re-offended. He's now in a prison. And, you know, he has spent a third of his life in jail. You know, and again, like I said, when he comes home, I have to wait till he comes home to get him any kind of real help. And that, in my opinion, is too late. And so I implore you to change how things are being ran, because heaven forbid another parent or mother go through what I went through. I wouldn't wish that on anybody, to have to watch your child be ripped away from you and there's absolutely nothing you can do. So, please see that you can guys just come together and make a change, because what you have now is not working. And it's causing greater harm than it is good. Thank you.
All right, thank you, Ms. Hogan. Ms. Hogan, Mr. Schindler.
Good afternoon, Mr. Chairman. Thank you for the opportunity to testify today. Mr. Chairman and members of the committee, my name is Mark Schindler. I'm Executive Director of the Justice Policy Institute, a national research and policy organization with expertise in juvenile and criminal justice issues. Over the last 2 decades, we've authored close to 20 reports on Maryland's justice system. I submitted written testimony, so I'll just offer a few thoughts and be happy to answer questions today. I come at this issue with a number of different perspectives in my professional career, but today particularly, I'm looking at this as from the perspective of having served as the director of DC's Juvenile Justice Agency during a period where we implemented many of the types of reforms that are recommended in the legislation today. I want to start by commending the legislature for creating the council. I echo Secretary Abed's comments and really want to lift up. This is the way to do public policy. The research, the collaboration, the time that went into developing the recommendations is exactly the way we should be doing it. And I think the package that was proposed, and I thank Senator Carter for putting that into legislation, is very sound and will move Maryland forward, hopefully closer to a model juvenile justice system. The package, I will say there has been progress in Maryland in recent years, but there's still a lot of work to go. We know the racial disparities are alarming. I think the work and the recommendations in this package will help us move in that direction, in a better direction. At the end of the day, what these recommendations are about is, in my view, is right-sizing the system, right? Is devoting our precious taxpayer dollars to the youth that are most at risk and most need our resources, and not spending as much time on lower-level kids, many of whom will age out and who end up getting hurt by the system. So this is really about right-sizing. It's about using taxpayer dollars most efficiently. And at the end of the day, it's about public safety, right? There are kids who need our attention, who need our focus, and who need us to devote resources. And the recommendations here, I think, will really help us do that, to focus on those young people. So I appreciate the opportunity. Happy to answer questions today. Thank you.
We'll have Ms. Talentino first from DJS, and then we'll take questions from the committee.
Thank you, Mr. Chairman. Betsy Fox Tolentino, Deputy Secretary at the Department of Juvenile Services. And I don't have anything else to add. I'm just here to assist with questions. Thank you.
Excellent. Okay, next we'll go to the committee for questions. Senator Castley.
I'm sorry, sir, could I ask you questions first? And I forgot, yes, you.
Yeah.
I'm sorry, I forgot your name.
If you could come to the podium, it'd be easier, just so, yes. That way the entire committee can see you.
With the mask, it's hard for me to hear what you say your name is, so I
Yeah, sorry, no problem. I'm just glad to be here in person. Mark Schindler with the Justice Policy.
Schindler?
Schindler, yes.
Schindler, okay, like Schindler, okay, gotcha. So you mentioned the racial disparities. Are you able to determine, because we've seen that time and time again, of course, it was referenced in detail on the Senate floor this morning, the racial disparities in the system. Are you able to determine whether, are those caused by racism within the juvenile justice system? I mean, is the secretary racist? Are the judges racist? Or is this some other innate characteristic? Is this a characteristic of the African American community that we're seeing in some of these? Are there challenges that are not because of racism within the system, but other aspects?
Yeah, it's a good question, and it's a complicated question in some ways. In some ways, it's complicated, in some ways not. I would not say that it's because of decision makers who are racist in our system, by and large. I think really this is an issue that goes beyond the justice system, right? And so it goes to things like institutional racism in housing, in education, in workforce, right? So all of those issues tend to come together and create more challenging environments, more challenging situations for communities of color. Unfortunately, oftentimes, that can result in people ending up in the justice system. We did a report some years ago about the amount of money that was being spent in Maryland corrections on the adult side per community. We looked particularly at Baltimore and saw that there was literally hundreds of millions of dollars being spent in corrections costs in communities that had lots of other needs. These communities happen to be overwhelmingly African American. It's that combination of things that results in a disproportionate number of people of color going into the system. There also is implicit bias that we see by decision makers. That's been documented and clearly researched. And so those things also combine to have people of color get differential treatment. The research is very clear on that. So I think we can't say it's any one thing, it's a combination of things that leads to those things. It doesn't mean there's nothing we can do, though. And so what we've seen in jurisdictions around the country focused on changes within their juvenile justice system is there are things that can be done, data-focused, research-based, to impact how decisions are made so that we do have fairer and more effective decisions. I hope that's helpful.
Well, it does, thank you. Do these studies include, I mean, when I look at it, you take a really bad school, only some of the children end up in the juvenile justice system. You take a really bad neighborhood, only some of the kids end up in the juvenile justice system. You know, any of these factors, it's a small number of the neighborhood. They may have brushes, but there's only a small number that actually end up deeply ingrained in it.
You're
and so
right.
in these studies you're talking about, I mean, do they try to make correlations between inter utero drug abuse or lack of care in utero, or a mother's education, father's education, two parents in the household together? Do they draw those correlations? I'm just asking because I want to understand. You know, we keep skirting around this, and we say, well, we have a disproportionate number of African American kids in this system. Okay, so we have two solutions. One is we just let them all go and don't do anything, or we say, why is it really just racism? Because then I say, well, who was the arresting officer? Oh, he was African American. Who was the judge? Oh, he was African American. Who was the probation? Oh, she was African American. Oh, and I'm like, okay, somebody's got to find me the racism here, unless African Americans don't like African Americans, which seems like a really odd dynamic. So I'm just trying to understand. You know, as we're looking, because we're really wrestling with this. I think in an honest vote, we're trying to wrestle. I hope we can wrestle with in an open dialogue that we don't be eaten up by political correctness. And so I'm just trying to understand what's out there to help us do this analysis to try to address the problems. Because clearly, we should not have, if you just look at the odds in life, you should have equal, you know.
That's right.
It should, you know, accident of birth should be accident at birth, not after. So what do we look at? How do we address this?
No, Senator Castley, I really appreciate the way you framed the initial part of your question about the fact that not everybody in poor communities or out of failing schools end up in the justice system. You know, what came to my mind, quite frankly, I teach a course at George Washington University, and we're just talking about these things with my students. And literally, you could have, like, maybe you've done the reading or you heard my lectures, because what you're talking about are some really important factors. One is resiliency. Right? Not all kids, in fact, most kids don't succumb to the pressures of the environment, right? And that's a really important point. But what you also pointed to are risk factors, right? We do know that there are risk factors, and when they accumulate, right, whether that's educational disabilities, whether that's poverty, whether that's coming from a family that has substance abuse issues, that these are risk factors that the more you have, the more likely it is that you'll end up being referred to the justice system, right? So that's sort of at the foundation. And then when we get into the justice system, again, I don't think it's, quite frankly, very productive to look at individual decision makers and their individual decisions. This is a systemic issue, right? This is institutional biases and racism that's baked into the system. And it's everything from how we deploy our law enforcement to how we spend tax dollars, right? Now, the good news is there's lots of research looking at exactly what you just referred to, looking at how kids who are similarly situated, right? Black kids, white kids, Latino kids, when decisions are made, how are they treated depending on the offense? And what we know, unfortunately, is that for a whole host of reasons, typically not because of an individual decision maker, that kids of color end up getting harsher treatment for the same types of behaviors, right? And the research is very clear on that. In Maryland, people of color get longer sentences for the same types of offenses in the adult system, right? So the research is pretty clear on that. I also really appreciate the way you're framing it, because this discussion oftentimes is a tough one, right? And we don't want, it's not productive to point fingers. I think it's productive to do what the council did, is really dig into the research and have dialogue about what's causing these things, what can we do to try to mitigate, right? Because the juvenile justice system and the actors within it are not going to be able to solve racism and poverty writ large. But there are things within the control of the decision makers where they can have an impact to make more equitable decisions.
I thank you. I just add, just as a comment back, that, I mean, that challenge I've always felt as a policymaker, a member of the Senate body, is that we don't really identify, we don't focus on the drivers. We don't
Yeah.
we get a list of inequities that are in the system, so let's kill the system because
Yeah.
it's not giving us the result we want. But when we get to how do we get into this,
Yeah.
we don't address those. We don't look at, let's look at how bad is this school? How many juvenile delinquents is elementary school or middle school X producing? And then say, let's focus on those two schools, because when you look at all the schools in the system, they're producing 50% or something like, we never
Yeah.
look at that. We
Yeah.
don't look at these other drivers and say, let's focus our efforts. So I appreciate it. Love to see anything else you have on that, but thank you very much.
No,
I
I'd be
appreciate
happy
it.
to send that. Well, if I can just say really quickly, and I think you're absolutely right. I mean, I think the process that the Juvenile Justice Reform Council went through, and I don't think anybody's suggesting that this is the end of the work. I think the recommendations are very sound and should be passed. But there's going to be more work.
I wasn't
that
going
needs
to take
happen.
you there. I'm not in agreement, but that's okay. I get it.
Well,
But I do have some questions, if I could, Mrs. Hogan, Mr. Chairman. I found her testimony
Yeah,
very
the
interesting.
last thing I'll say is I think this is akin to the justice reinvestment discussion that happened on the adult side, right? So it is about how we spend our resources, and I think this frames that discussion to happen.
Thank you. I appreciate that. Ms. Hogan, do you mind asking a few questions? Because you had really, I thought your testimony was very interesting. So you
Yes.
left, there were some gaps there. I'm just going to ask you some, because I don't have the full picture.
You're
okay?
fine.
You're
Go ahead.
assuming that we know stuff that it
You're
doesn't really come
fine.
out.
You're
So
fine.
now, how old was your son? How old was he when he got this incident where he was
13,
13? And what was that charge? What was
assault.
assault?
A misdemeanor assault.
Okay. And so then how long was he actually in the system before this other judge puts him back out? Release.
891 days.
191?
891 days.
So when you said this other judge comes in and reviews it,
Oh, I'm sorry. So it was 30 days. So the judge made him do another 30 days, and then he got out. So
So how did the
881 days.
okay, let me, it's not clear. So your son goes in, he's in there for 881 days, and at that
Correct.
point, another judge comes in.
Correct.
And says, go. So,
He says to him he wants to review the case and wait 30 days.
I got it. That's the
and
second
then-
judge.
Right, and then he let him go.
Okay, he's not a big part of it. It's the first judge, 881 days.
Right.
Now, during that period, do you know what your son was doing in the system? What was happening to him?
Is in terms of just being moved around and, yeah, I mean,
Were you ever contacted by anybody from the Department of Juvenile Services to talk about your son, his problems?
never. And
Were you?
I'm sorry, this is so hard for me because
I
I'm
understand.
reliving it.
But you weren't a hidden mother. You were openly
No, I was
acknowledged to be his mother.
absolutely very active. I've always been very active. I do a lot of community work, so I've always been very active, so.
So the Department of Juvenile Services has your son for 881 days, which is like, I don't know, I'm bad at my math, over 2 years.
So we talked. We would definitely have
would you talk to? Would you-
conversations.
Yeah.
But in terms of like being, two-way communication, I would say no. I would say it was more one-way, me communicating and contacting them. I had issues where like my son would be moved to another facility and I would not know that. I was not contacted by his probationer at the time. It was an out-of-body experience. It was very upsetting, and so, no, I would not say that none of that took place. None of that took place.
So what year, date-wise, when did your son go in? He was 13, and that would have been about what year?
2013.
2013, okay, so, and then he's there for over 2 years, so into 2014, 15, up into 2016 when he
Yes,
gets
he
back
came
out.
home, he was almost 17
Wow,
when he came home.
right. And there was never, and were you asking the department to, hey, can you review this? Let's get a review on this? What was-
Absolutely, the entire time. And I also had, I also had a therapist that was, he was recommended from somebody out, I think it was through his public defender, to come in and evaluate him, who also had submitted something to the court recommending that he come home, and this judge refused every single time.
So you're advocating for a review of your son. The public defender's office is advocating for that. Did
Yes.
anyone from the Department of Juvenile Services ever
Yes, they
advocate?
recommended that as well,
What did they recommend?
that he be returned home the
When-
entire time.
How do you know that was their recommendation? What were they doing?
I was in court.
Okay, and how many times did you end up in court?
Over the period of almost 3 years, pretty much 3 years, we had a review, I would say, maybe every 60 days,
Okay, and you would go to court each of those
Abs-
60 days?
every time.
Right.
Absolutely. And every time I was denied the ability to speak on my son's behalf, every single time. It was so upsetting that the public defender that was assisting us no longer works for the company. He's no longer practicing. It was a taxing case. It really was.
Did you feel that anyone was there advocating for you as the child's mother?
No. And because this was my first time going through this, I didn't know what to do.
Sure.
I had no idea. I'm not a Maryland native.
No, I get it.
Yeah, so I literally
Well, they're no
had,
better at dealing with this than you are, I can assure you.
yeah, like I didn't know what to do, and because this was my son's first time having any kind of interaction with the police, I literally didn't know what to do. So I crumbled under pressure, and it changed me.
And your son, in this 2.5 years, did his time in the system for 2.5 years, was there any improvement? Did you notice any improvement when he came out? Was he more responsible, more responsive, more caring, anything like that?
No, he was damaged. My son,
So he was damaged, is that what you said?
yes, he was damaged. I'm gonna tell you to the degree my son was damaged. When he was
Please.
finally released home, he was scared to leave the courthouse.
Why?
I don't
I would
know.
think he'd be running out of the courthouse.
Yeah, it was the experience was that overwhelming for him. It was almost like he didn't believe it.
Okay,
So,
all right.
yeah, it was a lot.
And so then he came home, and then how long before, then you say he ended up in the adult system, how long did you actually have him home for?
A year.
A year?
So, yeah, so we tried, did the in-home therapy, tried the in-home therapy, he got a job, he was trying, but it wasn't, he still, he ended up stealing a car with his friends, and here we are.
And after he got out, was there anybody other than you? Was there anybody in the system to help him? Did he have like a probation agent or something to come around and check on him, or was he just released?
He was just released. I take that back. He had a probation officer in the beginning who is no longer, I don't know where she went on to, but she was probably his best advocate, and that was when he came home. She was very supportive. She, would go visit him at school. She definitely connected with me. I truly appreciated her because she tried to help me impress upon Michael, what he needed to do for probation.
Did you feel that was what she did was having a positive effect on Michael? Or-
Yes.
So do you remember how long you had her services for, the probation agent?
I want to say maybe 6 months after he came home.
And then she leaves, and then 6 months he has no money, and then he steals the car.
So now I think somehow it got switched to like an adult probation officer, and that's when things went bad. Because my son also, because of this time, he has mental health issues now. And so I was dealing with so much, And I was overwhelmed myself, and I absolutely would reach out to his probation officer for some relief. And I hate to say it, but at those times, I felt that it would have been better if he had been violated just because of the things that I was encountering. He was very angry. He had damaged property. He kicked my front door in. It was, and what can I do?
Would it have been, do you think you might have had a better outcome had that probation agent, the woman I think you had for the first 6 months, you think if she'd have stayed in for the full year, that maybe your son might have had a better outcome if she could have been with him and you?
Yes,
Okay, all right. Thank you, man. I really appreciate your testimony. You're very helpful. Appreciate it.
thank you.
Thanks for coming in.
Okay.
Ms. Hogan, just for a point of clarification, was your son in the juvenile system the entire time before?
Yes.
He's still the car guy?
Yes, every facility in Maryland.
Got it. Okay, Senator West.
Thank you, Mr. Chair. I admit to being a little confused. I'm trying to read this bill, which is quite lengthy, and find in it the recommendations that our task force submitted. So let me start with children under the age of 13. On page 1 of the bill, it states that the court, meaning in this case the juvenile court, has exclusive jurisdiction over a child, and then it goes to, except as provided in subsection D, who is at least 10 years old, alleged to have committed an act, and a number of acts are listed. Do you see that, Secretary Abbott and Ms. Tarantino? But then on page 5 of the bill, under subpart F, it says a child under the age of 13 may not be charged with a crime. Aren't those two provisions inconsistent?
Let me go to the podium.
Yeah.
We'll certainly check the language, Senator, but the recommendation that came out was that from essentially 10 to 13 was a special carve-out, if you will. So only for those, I believe, crimes of violence could you have jurisdiction there. And then for everything else, it would be under 13.
Right, and that's the language that's contained on pages 2 and 3 of the bill that has all the carve-outs that we talked about. But then over on page 5, it says a child under the age of 13 years may not be charged with a crime, which just seems completely inconsistent with what language on pages 2 and 3.
So I'll need to double check the language to make sure that the drafting was in accordance with our recommendation, but
We'll look at it.
yeah, we'll definitely look at that, and if it needs to be changed,
Okay.
we'll make that change if that was in fact an error, but I need to review that in more detail.
Okay, so that's one thing, but then the other, the more significant issue was what the one issue in which some of the opinions on the commission diverged, and that is whether a child was going to be charged in adult court or in juvenile court. As I read this bill, it says the juvenile court has exclusive jurisdiction over a child who is at least 13 years old, alleged to be delinquent. That covers everybody over 13, and it goes to the juvenile court. But then on page 4, it says the court, again meaning the juvenile court, does not have jurisdiction over, subpart 4, a child at least 16 years old alleged to have committed any of the following crimes. And then there's a long list of crimes. We had a conversation shortly before we came to this hearing in which you expressed to me your view that all cases should start in the juvenile court with a lower standard of lower burden of proof for the state's attorney to waive them up to the circuit court, to the adult court.
Senator, I believe that is a separate bill for
Oh.
youth charged as adults. That is not part
All right,
of
that's not in this bill.
Right,
Yes.
so we separate, this is the first round of recommendations from the first convening of
Okay.
the Juvenile Justice Reform Council.
Right.
The recommendation that came out of the second convening is in a separate bill. I believe that's Senate Bill 196, Senator Carter's bill.
Well, this is also Senator Carter's bill.
Right, both are sponsored by Senator Carter. The
Okay.
youth charges adult piece, that came out of the second round.
All right, so I've been
The JPRC
frantically
is a
paging
separate
through this.
bill.
I've been frantically paging through this bill trying to find that
Right, yeah.
language unsuccessfully.
Yeah,
So
that's
that's the
on this
reason. All right, well, could you check into the 13-year-old question? And
Absolutely.
get back to us? Thanks.
All right, while we have the secretary up, oh, sorry, Senator Carter. All right, I just wanted, so you heard the line of questioning from Senator Casserly. And Ms. Hogan, thank you for providing those answers. But I think it's important, the committee really needs to understand the scope of services that are provided in the juvenile system, why, her son was moved around, what was available to her, vice the adult system. I think we need to have a crystal clear understanding of what resources are there and how they're delivered and administered to people as they go through. So if you could just explain, just give us a 50,000-foot level view of what services are available to folks that are entering into your system.
So in terms of services available, we have probation services, we have community-based services, we have all the range of interventions, both in the community and in residential services. Ms. Hogan's son, I believe, was in a residential placement. And, I am fearful of commenting on her specific case without knowing exactly, the circumstances. But from what I heard a misdemeanor assault was the basis of the commitment. And I think that when you look at this legislation, that's the kind of thing that we're saying should not be something that a youth should be incarcerated for, because it is damaging to bring somebody in, certainly for that period of time on a misdemeanor assault with no prior record in the system. That is, and I think that's part of the reason why we have these recommendations, because we do recognize that there is damage that will be done if we bring low-level offenders into our committed system, where we are setting that system up to deal with high-level offenders. So in other words, we can do a good job with somebody that is a high risk to the community, but if we bring someone that's low risk, we're going to do damage, and I think that's what she's experienced, that it is very damaging, and we shouldn't do that in the first place.
No, ceding the point that, her son shouldn't have been there in the first place, but just again, some of the just trying to draw the distinction between the adult system and the juvenile system, understanding what services are available, and why that would be beneficial to prevent recidivism and for long-term outcomes. Just trying to understand, or if you could point to a resource where we could show, hey, if you're in this system, you can avail yourself of these 5 things. They're just not available to you in the adult system, for example. And that's what we need. That's the information we need for this committee.
Mr. Chairman, if I may, the juvenile system is designed to, at immediate contact with young people, do an assessment. And when we do an assessment, we identify the needs. And we do that continually through every stage of the system. So if a young person comes to our attention and presents with certain needs, then we provide them those services right away. We have evidence-based services that are proven to reduce recidivism. We have access to behavioral health services to support young people in their communities, or if needed, out of home. We have access to substance use services in the community. We have access to peer support, mentoring services in the community. We have an array and a strong continuum of care that is designed to meet young people's needs. That's at the front door, that's at probation, and then that's also at commitment. All our programming, treatment, how we operate day to day is based on helping young people get what they need so that they don't have a risk of offending in the future. It's how we operate. That's a difference than how an adult system would operate, which is providing services to meet the needs of adults.
So Senator Carter, go ahead. I've got questions for Ms. Egan, but I want to go ahead and I usually just take the last question. So go ahead, Senator Carter, and then I'll ask Ms. Egan. I have a question for you. After
Happy to let you have the last word, Mr. Chair. I think this may have been resolved, but I just wanted to clear up a couple of technical points. The Senator West, the Youth Charged as Adults bill is Senate Bill 165, as Ms. Tolentino indicated. Also, I don't see the the potential error that you see in this bill, but if it is, we can certainly talk about it. It says that the child under the age of 13 shall not be charged in the system unless, and then it goes into situations where they can. But if there's an error, we can certainly fix it, but I don't read it that way. Finally, my question is a little off. It kind of goes back to Senator Cassidy's questions to some extent, because I've had some personal experience, professional experience with the juvenile system, and much of what's already been discussed I've seen, which is that there's often a disparity in the way children are charged, and often race is a factor in that. But one of the things that really comes to mind when we talk about systemic racism and the things that contribute to children being in the system, I recall for many years when I was in the House of Delegates, there was this document after document, research after research, that showed that children that are exposed to lead-poisoned children are about 6 times more likely to wind up in the juvenile system, and that lead poison is a number one, I remember reading one research report that said is a number one precursor to juvenile delinquency, also just cognitive issues and just a myriad of things that permanent brain damage causes. And so when we talk about systemic racism, I would just point out that our failure to do the adequate things to address lead poison likely are a contributing factor. In fact, it was only 10 years ago in 2012 that the Court of Appeals struck down our law that existed for so long and said, hey, what you're doing for lead poisoned children is not amounting to any compensation at all. So that being said, that's the foundation. I was just wondering, Ms. Tolentino or Secretary Abbott, do you have any numbers, not just for like data for today, but throughout the course of time, of the percentage of children in your system that have lead exposure? Thank you.
I will need to get back to you on the specific numbers, but I have spoken to our research team about lead poisoning, and what we've seen is there is a correlation, and as the rates of lead poisoning have declined, so have the rates of delinquency. And I can get you, I think, that data.
All right, great. So I guess, Ms. Egan, a question. So just following up again, I mean, because I thought Senator Cassidy's line of questioning was instructive, and, I'm not going to impugn anything, but I mean, look, it reveals some of the maybe less ideal outcomes of this type of interaction. So the question is, from the recommendations that have been kind of put into this bill, how would this bill, fix what happened in that instance? Because that's, I mean, I think his line of question reveals, a vulnerability and a problem.
Absolutely. So the thing that Michael's case illustrates is the need for this bill very much. What we know of, and all due respect to the Secretary and Ms. Tolentino, there's rarely a bigger critic than DJS in Maryland than I am. There are lots of shortages and problems in the system. Our argument is that part of that is because so much of our resources are going to low-level offenders. Remember, prior to the pandemic, 2/3 of kids being taken out of their homes were being taken out for misdemeanors, like Michael, or technical violations of probation. And what we know is that when you take low-level offenders and you take them out of their home and put them with more criminogenic peers, things get worse. And that's why this bill sets a minimum age, so we're not bringing kids in for low-level school behavior. I've represented in just uncountable numbers of 10-year-olds brought in for school fights, for throwing rocks on the playground while playing red tails, right? So the goals of this bill to raise and create a minimum age, to ban incarceration for first-time misdemeanors, is not just about serving those kids, which is helpful, but also shrinking that system so that DJS can use its resources and focus them on the higher level kids and the higher level needs. For Michael, if this bill were in place and he had a first-time assault, then Judge Dawson, who was featured in the New York Times for these kinds of abusive practices and for incarcerating low-level offenders, if Senator Cassidy, that happened during the time that Michael was going through the system. So that if Michael were to come before a court cannot take him out of his home and send him to a incarcerate him for that low-level offense. He has to get what are the right-size services, which are community-based services for first-time low-level misdemeanors. And I would argue that if there are not Michaels flooding all of our youth facilities, then DJS can better use its resources to better treat a smaller number of kids in those facilities and a smaller number of kids in the community. So I think that this bill does a number of things. One, it makes diversion easier so that we can put in place better treatment sooner for kids like Michael, so that they don't have to go into that court system, so they're not sucked deep into the quicksand of a carceral system. But two, it would also ban that incarceration, so a judge can't overrule all the experts, every evaluator, and everyone else. But third, once we remove those low-level offenders from the system, DJS will have the resources to focus on the intensive wraparound services it needs for more serious offenders. So this bill not only addresses what happened to Michael from the court, but will also free up resources so that DJS could have better served him when he did get released back to the community. Does that answer that question? Yeah.
No, it does. I mean, because look, I mean, obviously, Senator Cassidy, I'll pitch it back to you, but I mean, look, the line of questions was used to expose a vulnerability and, you know, and it outlined a less than ideal outcome. And I understand that several elements of this, it was well said. I'm not going to reframe your argument, but go ahead. Senator Cassidy.
Yes, sir.
Good to see you again. So my problem isn't with so much the age reduction, okay? I think through that, but you make some good points on that. It's that once you get these other kids out of there, this bill still limits the periods of probation. And let me tell you how I see that, right? And what I see is that aspect of this bill, it's just very, it makes this a very terribly cynical bill that will basically flush children through a very broken juvenile justice system that has proven that it is grossly incapable of serving their needs. And so, because the part on limiting probation, that would still be there. You know what, if you see the number of kids go from here to here, you've still got that limitation. And to me, that's a serious problem because, as Michael's mother said, he could have used more time. He could have used some more time with that worker. He had problems. His own mother admits Michael had problems. And we're not dealing with those in the system. The system, what the programs we have don't seem to me that they're doing much to help the Michaels of the world. Even if you only have Michael on his own in there, if he's the only kid, we're not dealing with that. And then we're really quick to just say, our numbers aren't right. It goes right back to the professor's point about, you know, instead of, we have a disproportionate number of African-American kids in the system. So instead of dealing with their problems and saying maybe Junior needs a year on probation or 2 years, he's got serious problems, whether that's lead paint, whether that's, I don't know what, you know, all those other factors. Maybe Junior needs more than 3 months or 6 months. Why not tailor the probation to the period necessary to address Junior's problems and not to simply flush him through the system? It seems like we're modeling this after the Baltimore City school districts, which are simply, we see the reports, where an entire school basically graduates nearly illiterate. It's a check the box. Did you give them 12 years? We're done. I don't care. Can you read? It doesn't matter. Check the box. Seems to me that juvenile justice is modeling this outcome to modeled after that. And quite frankly, to call this a bipartisan bill is like calling the bipartisan redistricting commission a bipartisan bill. Everybody knows that was not a bipartisan commission, and the maps reflect it. And we're copying that. You know, the bipartisan stamp's supposed to be this, oh my gosh, it's endorsed by God, bipartisan. It's not a true stamp. And I wish we could just, you know, to say that's an endorsement is a sham. So that's my concern, is that I have no problem with dealing with these kids.
Yeah.
I mean, I want us to give them the services. It's not, they weren't born criminals. Things happen in life. I mean, I got lead paints kind of comes up maybe in utero, but these kids have problems that they encounter, and we should put the resources necessary to help them overcome those problems. However they got there, that's not the point. Junior has problems, and if it takes us 1 month or 3 years to help Junior through, whether that's, you know, an inpatient type of deal or just wraparound counseling that goes on for 2 years, I don't want to cut that off. And to me, this is a cynical bill that just says, check the box, Junior's done, gave him his 6 months, his 3 months, goodbye. So that's my point with this. Thank you.
Yeah, so I hear you, Senator, and you know, I have no lack of critique for DJS services. part of limiting that and shrinking the system or right-sizing the system is not just about giving a child services, but also holding the adults in the room responsible. When you say DJS can have probation over this kid for as long as we want and we'll get to it when we get to it, what that means is that referrals take 60 days instead of 6 days.
But isn't that a really sad commentary on the system then? A system that's incapable of using its power appropriately, and I hear what you're saying, but you're saying, look, it's better just to throw them out than leave them in this system. Seems like this reinforces my point. The system is bad, because if the system wasn't broken, you wouldn't feel like you had to get them the heck out of there because it's not helping them.
Yes and no, right? So it is.
It's the yes part that
It's
bothers me.
it's but and both, right? I definitely agree with you in part, but we have to hold the adults responsible. We have to say you have to provide services in a timely way. But that is because of the nature of kids, right? So if you have a probation condition that happens 18 months after a kid stole a car, a 15-year-old is not associating what happens to him in June of 2022 with what he did wrong in December of 2020.
As a parent of 5 kids, I totally agree with you on that point, but it seems like the system ought to be able to say, why does the system have to be told that as a matter, why do we have to cut it off? The system ought to be wise enough, responsible enough to make that determination on their own if we have the right people in there, but obviously, that's a challenge.
One, DJS
I'm on your
doesn't,
side, so-
I hear you, I get the point. But I
Seriously.
will say, setting those developmentally, and the other thing is, if Junior hasn't committed a new crime, then maybe those ongoing services aren't necessary to avoid delinquency, and that's all the system should do. Once we've gotten past the threat of delinquency, Junior shouldn't be getting all his needs met by DJS. If Junior needs counseling because he needs to process something, that's something that can happen in another system, and DJS isn't appropriate. For too long, we've used DJS, cells and cages, incarcerating children as the backstop for the failures of our other child-serving agencies. It is inappropriate, and that's why these probation limits are so important.
I'm just curious, do those other agencies, do they have, because let's face it, sometimes families won't cooperate, sometimes Junior won't cooperate. Do those other systems have the ability to say, you will cooperate, you're going to, whether you want to or not, you will cooperate? Do they have that ability? Because sometimes, you really got to have a little bit of a push there to make people help themselves.
We may disagree on what works about carrots and sticks and helping families, but certainly there are plenty of coercive state mandates for parents and children that require services and for them to be engaged in them, especially around truancy, especially around schools and the children in need of assistance
It'd be interesting to learn some
system.
of those. But thank you very much. I appreciate it. Good to see you.
Thank you, Senator. Appreciate it.
Thank you. Ms. Egan, if I could keep you up there for a little while longer. I totally understand what you're saying about the new focus on those who most need services or most need to be engaged with the system and those engaged in more serious crimes. And you talked about making sure that the children who are engaged in first-time or misdemeanors should be getting services elsewhere. Kind of, what does that look like? So that we make sure that they don't up their game and come back?
Yes. So what we know is that for low-level misdemeanors, for kids who are first-time offenders or encountering the system for the first time, the number one way to ensure they'll come back is to put them in a cell, right? To incarcerate or detain them is the number one way to increase recidivism. Children who are incarcerated versus those who aren't go on to offend more and less. But there are plenty of systems in place to take care of them. One, there's local care teams for kids that are younger, right? So right now, say you're an 8-year-old in Howard County and you throw a rock through a window. Generally, you're not getting arrested, where an 8-year-old in Baltimore City likely would be arrested. And that is some of those things that are just baked into the system. Common practice, what police officers are used to, what parents are used to, what has happened to those communities over time. There are other systems to take care of that. First, the children in need of supervision system, and that statute is able and is compulsory for families to engage in. The children in need of assistance system, if there are neglect or abuse issues, the education system, and then through GOCAP, we have local care teams in every county that has multi-system stakeholders of every child service agency where any family can be referred to anywhere in the state right now. So those local care teams are a good sort of place where all the resources for referrals and where people can coordinate better, much better than sending the kid to a detention facility or arresting him and hoping that eventually a judge will order and he will get some sort of services. Those other services are also much more quick reacting forces, and that's why they're so much more appropriate for low-level misbehavior and for younger children. Does that answer your question, I hope?
It does, that's helpful. And do you believe they have the capacity, they should go into effect to be able to deal with the increased numbers of students, children?
I mean, the budget of the Department of Human Services is vast and enormous, but also what I want to note is for too long, those systems have taken and started when kids turn 10, 11, and 12 to say they're no longer kids, right? When teenagers are harder to deal with. Anybody who has had a child knows teenagers are harder to deal with. And if we don't start saying you cannot simply, when a child is difficult, use DJS and incarceration as a backstop, and we force those agencies to actually deal with our mental health challenges, with our neglect and abuse challenges, we have to ask them to be responsible for the young people whose needs are not related to delinquency. And for the vast majority of kids in our system, especially those younger kids, they are crossover youth. They have involvement in both systems. And we have to stop treating kids who have been failed by us as adults, failed by their school system, failed by the CPS system, failed by our systems. We can't simply say, well, you turn 13 now, you go into a cell. I think it is paramount to make sure those agencies take responsibility for our children and making sure that they transition into a healthy adulthood.
Thank you.
I hate to, I've used up my time, I know, but I look at this bill, it seems like everything in here, unless I'm missing something, is to limit children's time in the Department of Juvenile Services. I mean, every aspect of this bill says, get children out of the system. I don't see anything here that says, we identified this problem with Department of Juvenile Services, and we need to change that. And let me just give you an example. In my county, there's the Maryland Free State Academy program. I'm sure you're familiar with that.
Yes, sir.
And I go to the graduations for that. And it's heavily African-American. These are kids from the region, not just Maryland. And you sit in those graduations, and it's hundreds of kids. And they're phenomenal. And the stories they tell, you can't get out of that without crying. And the kids' reactions and everything. And these are kids with tough life. I mean, these are kids who were drug runners, or, you know, the gun carriers for big drug rings. And how it turns their lives around. Things been the same size. It's not been, I know it hasn't been modeled other places. We do a lot of that goes towards kids from out of state. So I look at a program like that and like, oh my God, if we get more kids into a system like that where they're given so much, you know, the discipline they get, which is a nice level of discipline, and the stories that come out of there, are we looking at things like that? Are we taking these models? Is anything in this commission that looked at to somehow, you know, identify those kids that can go into a system like a Free State Academy and copy that model in Maryland and turn somebody's lives around? Because I got to tell you, the one guy who was a gun carrier for a drug ring, he was a guest speaker coming back. He was now an accountant, a successful accountant in D.C.
Absolutely.
And his life had been totally turned around by this academy.
Yeah, so I'll just say DGS has a very close relationship with Free State Academy. I've sent, lots of my kids have gone there, and you have to have special court orders to be able to go if you're on probation, but they work very well with DJS. What we know about Free State Academy and lots of programming for kids is the same thing doesn't work for every kid.
I get it.
Right, so my dad's a Marine, so Semper Fi, you could have sent me to Free State Academy, I love bed checks and that sort of thing, but if you would have sent my brother, I promise you he would have bucked on day one, just because his issues as a teenager were very different than mine, right? And that sort of authority. So what we need is multi-tiered things. And yes, there were great recommendations from the JJRC that are faced towards DJS and are about DJS accountability that are not legislative and not in this bill. One of them was to make sure that there are community-based and residential programs in every region of the state. And I think that is a terrific example of why those things are needed.
Yeah, and there's certain parts of this bill that I have a hard time challenging, but it's sort of regrettable that we're not using this, it seems like we're not using the system we have in an appropriate fashion, and that's the regrettable part, because I think a lot of the, and you talk, I mean, the kids going to GGS Academy, the Free State Academy, their dads were not, I mean, you talk to these kids, these were street kids, no discipline in their lives, but for the, I mean, this one kid, for the first time in his life, a mentor, a tutor sat down and showed this kid that he liked numbers. It was the first time he ever worked with numbers. He went from failing in math to loving numbers because he could relate to it, turned his life around. He actually realized he had a talent for numbers and went on to college and with a very successful life. But it's that kind of thing because it's not marine discipline. A lot of it is eat the right foods. Don't spend your life on television and games.
Life skills, yeah.
Exercise, basic life skills. Exercise in the morning, eat the right meals so you're not fast food stuff.
Yes.
Study. It's not push-ups. It's not that kind of stuff. It's the kind of discipline that any parent would give their child in a normal day. It's just that you have to live that. But anyway, thank you very much. I appreciate it.
Thank you. Thank you, Senators.
All right, additional questions from the committee? All right, seeing none, thank you all very much. Thank you.
Thank you.
All right, we'll now move on to the next panel. We'll hear from James Dold, Marlo Tilgman, is Garrett O'Day, and Nick Maroney.
Thank you so much, Mr. Chairman. James Dole, for the record, representing Human Rights for Kids. Just want to start at the outset and thank Senator Carter for her leadership in introducing this important piece of legislation. I'm going to be speaking directly to the first section of the bill that establishes a minimum age for juvenile delinquency. The reason we are here to speak in support of this provision is because establishing a minimum age of at least 10 is, in fact, a human rights issue that's outlined in Article 40 of the UN Convention on the Rights of the Child. This is important because what we know about kids is that they're fundamentally different, especially younger children. The prefrontal cortex in children is especially not developed, and children, particularly young children, rely on a more primitive part of their brain known as the amygdala to make decisions. It's why we place all sorts of social restrictions on them. This is especially true, as I mentioned, for children under the age of 10. And this particular provision is important because children under this age simply, in our estimation, do not have the capacity to form mens rea. They are not competent to stand trial, and they can't even grasp basic legal concepts, which is why provisions like this are so important. These common sense reforms are also why conservative states have actually led the way on this particular provision especially. So when we look at Louisiana, Mississippi, Arkansas, and Texas, they have all passed similar legislation, which has also been endorsed by the Conservative American Legislative Exchange Council. The last thing I want to note on this, which is really important, Mr. Chairman, is the fact that when we're talking about these kids, I think it's important to note the social backgrounds in which these kids come from. We are talking about children who've experienced unimaginable childhood trauma. There was a study that was done in Florida where they found that 90% of all the children in their juvenile justice system had experienced at least 2 adverse childhood experiences, and 48% had experienced 4. That includes everything from physical and sexual abuse to neglect to having a parent who is incarcerated. So when we peel back the layers of the system and we begin to analyze what's going on in these children's lives, we understand that it is trauma. That is the root cause of why so many kids end up in the system and why this legislation is so important by shifting kids out of the system into trauma-informed services. And so with that, Mr. Chairman, we would urge the committee's favorable report. Thank you so much.
Good afternoon, Chair Will Smith and Honorable Senate Judicial Proceeding Committee. My name is Reverend Dr. Marlon Tillman, and on behalf of Bridge, Maryland Incorporated, we support Senate Bill 691. I am grateful that we can testify and answer clarifying questions to this committee. However, I'm also wondering why we can't ask questions. Questions like, what more do you need from us? We have provided state, national, and international facts on how to protect our children from child trauma, false imprisonment, and countless other acts that lead our children into a criminal justice system that needs to focus more on treating the sin and not punishing the sinner. We provide moral, empirical, and social data on the effects of childhood trauma, child brain development, and long-term effects on adult development, and yet legislation like SB 691 and companion bills are not scheduled for vote. What more do you need from us? Set aside for the moment that you may have children or grandchildren and simply remember that you were once a child. Would you want one or two mistakes that you made in life to impact your future forever? That is what is at stake in passing Bill SB 691 and its companion bills. And to our opponents that say they're trying to perfect these bills, I have a question. Why would we let perfection be the enemy of good? Finally, are we living in communities so far removed from children we're trying to protect that we forget that impacts one directly, impacts all indirectly, emotionally, socially, and economically? Our children need care, not cages. Our children need your empathy, not your sympathy. We urge this committee and the Senate to issue a favorable report on Senate Bill 691, the Juvenile Justice Act, and its companions.
I'm going to let the clock run out, sorry. Thank you, Mr. Chair. Thank you, members of the committee. For the record, Garrett O'Day, Deputy Director of Maryland Catholic Conference. I first want to mention the coalition support of this bill. The Maryland Youth Justice Coalition is a conglomerate of the Maryland organizations such as the MCC, OPD, Bridge Maryland, Strong Future, ACLU, and others, as well as national experts, Human Rights for Kids, R Street, Sentencing Project, and what we would submit today is that this bill allows for more diverse ways to address underlying issues. As the United States Conference of Catholic Bishops have continually stressed the importance of restorative justice measures, I want to make mention of that aspect of this bill, which provides for an increase in restorative justice measures through diversion policies in particular. I think Senator Carter mentioned the model policies within the bill. Diversion policies help address underlying social issues that underlie the commission of offenses and such as substance abuse treatment, mental health treatment, etc. So this is a well-crafted, deliberated bill over a couple of years, and the sweeping reform bill, just as we did with the Justice Reinvestment Act some 6 years ago. Some opponents argue that youth crime is on the rise, and if that's true, whether or not it is, we would submit to you why would you not want to change things in order to address those issues. I would also ask you to consider the implications of public safety of this restorative justice policy in this bill. These policies seek to reduce recidivism, so if youth are less likely to reoffend as adults, we would submit that public safety, in fact, increases in the future. Thank you very much for your time and consideration of this bill, and we urge a favorable report.
Chair Smith, Vice Chair Waldstreicher, honorable members of the committee, my name is Nick Maroney, and for the past approximately 15 years, I've worked for the Independent Monitor's Office in the juvenile realm, performing unannounced visits to DJS placement and detention facilities, placement being the equivalent of the adult prison. We found tremendous improvements there, and over the past 10 years, we've seen DJS act positively and the courts act positively to try to make sure that kids who don't need to be incarcerated are not incarcerated but are diverted out of the system. A certain judge was mentioned, so the name is out there. I have been in a situation where when I started as a monitor, I was monitoring Cheltenham Detention Center in Prince George's County. When I was there, there was 144 kids on site, many of them in plastic boats on the floor, primarily because of the actions of the particular judge in question. To make some more connections, the lead paint problem is huge. There were a number of sharks involved in that particular issue that came in and offered pennies on the dollar to people who were awarded monies because of their exposure and the negligence involved in that exposure to lead paint. The folks involved, the attorneys who were taking advantage of these people, did not bring their cases which originated in Baltimore City to Baltimore City courts. They went down to Prince George's County. They came in front of that same judge, and that same judge was fine with those families getting pennies on the dollar. So that's all part of the scene. There are probably just a little more total youth population in detention today under the DJS system as there was in Cheltenham on a given day when I started. What happened to the child is a travesty that we heard earlier on, Michael, okay? But what could have happened is that that child would never have been incarcerated in the first place, but would have been on probation for up to a year, during which time he could have received services in the community, which would have been plenty and adequate time to take care of an issue that did not sound that serious. But if you take a child and put a child into the system for 2 or 3 years that should not be there, doesn't matter what kind of treatment you have, because that treatment is going to long since have run out and wasn't even directed towards the issues that kid had in the first place because it's a low-level kid. So I don't think blaming DJS for that particular situation is an accurate way to go about things. I think this makes some moderate changes, and I'll wrap it up, thank you. Moderate changes that need to happen so you don't have very young kids pushed into the system, so you don't have folks deciding, you know, this is justice in this jurisdiction, and then a completely different approach to probation in another jurisdiction. And so for these kinds of reasons, and those kinds of reasons alone, I strongly urge you to support this bill. And by the way, as I said, we watchdog DJS, we look at things objectively. This is a good bill.
Thank you very
Please
much.
support it. Thank you.
All right, thank you. Always by the way. Oh, by the way. All right. No questions for this panel. Thank you all very much. All right. Oh, I'm sorry. There is a question. Sorry. Go ahead.
It is for the pastor. When I think about this bill, you know, I like this bill. It's a good bill, and it signifies the redeemability of our kids. It recognizes that the stigma issues and challenges when our kids are exposed to a system at a certain age. However, I want to pull a little string here that my colleague Senator Casserly brought up, because what we're doing here happens at a point where damage has already been done to these kids. And I don't think that this really gets at the root cause. My analogy is a school. There are no good schools and bad schools. Schools are a microcosm of the community. So if there are issues in the community, they will eventually make their way into the schools. You had mentioned you had done some research and you're working in the communities. And my question is, what can we as legislators do today, based on your expertise, to impact these kids at home? You know, when I went to visit a school that is in the Baltimore intake program, those kids were performing at high levels. As soon as they were released, they went back to their home environment, and things went right back down as if they never had that level of discipline, that level of support, that infrastructure that they lack at home. The reason we spend so much money on our school systems, especially in Prince George's County and Baltimore City, is because there's a recognition that our kids are the most impacted. Not only in levels of poverty and free and reduced meal and special education and English language learners, but the fundamentals of broken families, the impacts that has for a long period of time. These are things that we grapple with. And again, I want to thank Senator Casserly, because he's one of those who are willing to stand up and have the tough conversation. If we want to really rectify the issues with crime and get our kids on the right track, we have to go back a few years. What used to work? What are the holes? And how can we fix it instead of waiting till they knock on the door of a correctional facility and now we're trying to figure out what to do at that point? And I'd love to hear your comments. Thank you.
So, the Reverend Dr. Martin Luther King said there were triplets of evil: war, poverty, and racism. When you ask me this question, I think about the word on poverty. When you talk about sending a kid back to the same community they're living in poverty in most cases, right? Which means now you have a parent that's working 12, 13, 15 hours a day and still trying to care for their child, and they might have multiple children, or they might be fathers who are outside the household. When you're dealing with poverty, sometimes when you send those children back to those communities, you're sending them back to a situation that's making it difficult for them. So as legislators, this is not your committee's responsibility, but as legislators, if you could help deal with the poverty in our communities. When you send that child back, perhaps the child would have more time with their parents because they're not working 18 and 20 hours a day in order to put food on the table.
Thank you for that. Appreciate it.
Very successful, excuse me, African-American parish in Bel Air, and he does a great job, and I really appreciate you coming down here today, Reverend. Thank you.
Thank you, Chair.
From earlier.
All right. Seeing no further questions from the committee, thank you all very much. It's very good. Thank you. Next, we'll hear from Mikhail Gross.
Do I get a panel all to myself? Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth. I'm testifying today in support of the Juvenile Justice Reform Council's recommendations, but specifically focusing my testimony on the recommendation to raise the floor for juvenile jurisdiction. Quite often as public defenders, we represent kids who are very young, being prosecuted for acting like kids. This is especially true when we represent preteens. The charges that they're coming to court for are not serious charges. Half of the children under 13 charged through the Department of Juvenile Services are charged for property offenses. And 1/4 of all children under 13 who are charged in the state of Maryland are charged for misdemeanor assaults. And even those charges are just kids being kids. The assaults that we're talking about, those are situations like a middle school kid squirting juice at a kid that he likes. The malicious destruction of property charges, those are 5th graders who break a window when playing basketball. And 11-year-olds who are arrested and charged for coloring on their friend's jacket at school. The theft charges, that's a middle school kid who took a bag of chips from the cafeteria, and that's a 9-year-old who rode a bike that was left in his yard. And the problem with charging these kids is that children under 13 do not understand court. They don't understand their rights. When they hear the word rights, they think their right and their left hand. They don't think about affirmative rights. They might think about right and wrong. And they don't understand the adversarial process, why someone who might be their friend would testify against them at a trial. And they can't understand the long-term consequences of juvenile court. Try explaining to a 10-year-old that they can be held at an out-of-home placement up until their 21st birthday. That's more years than they've actually been alive. And the problem is that we're causing harm when these cases come to court. I will just quickly say that more than half of the cases of children under 13 don't actually make it to court. So why are we traumatizing these children? Why are we allowing a 10-year-old to be placed in the back of a police car, taken from his grandmother's custody, handcuffed with lights and sirens, to be taken to a police station to be interrogated for charges of kicking a car? I have quite a bit more that I would love to share if I had more time, and quite a few different stories that I could share about specific very young clients and how they did not understand what happened in court, and how they were traumatized through the process. Thank you.
Thank you very much. We have a couple questions, so we'll go with Senator Huff first, and then we'll go to Senator Hedelman.
I just have a question, and if you don't have the answer, if somebody else has it or somebody can get it to me, I'm curious, because how many children are actually being charged via the school system, number-wise? Do we know a year?
So the Maryland State Department of Education does publish the number of school-based arrests. I don't know that number off the top of my head, but can very easily find that for you. Unfortunately, the last few years are not going to be fully accurate. The most accurate data will be the 2019-2020 school year. I'm sorry, the 2018-2019 school year, since that's the only full school year that we've had so far. And I can get those statistics to you later, but they're published by the Maryland State Department of Education.
Okay, thank you.
The examples that you gave, were those real examples of children that you have represented?
Every single one of those examples, except for one, is a child that I have represented. The one example that was not a child that I represented is a child that a colleague of mine represented.
And those are all cases where a state's attorney is making a decision to charge that child. Is that correct?
Some of those cases did not actually make it to court. Some of those cases were just charged by a police officer and then closed by the Department of Juvenile Services at intake. But even that process on its own causes trauma, inflicts trauma on that child. So that middle school kid charged with taking a bag of chips from the cafeteria, that's still a traumatizing experience when they're charged, placed in handcuffs, and I'm sure, I know you understand that. So most of these cases, though, are cases that actually come to court because I wouldn't know about them unless they came to court. But every once in a while, I've given an example that was charged and maybe closed by the Department of Juvenile Services at intake.
Okay, and just as a follow-up, can you walk me through the process for stealing the bag of chips and how it gets to you
Okay.
in the court?
That specifically.
And the system.
Yes, that specific incident did not actually make it to me. I believe it was
Another
closed
one.
by the Department of
Yeah.
Juvenile Services. But what does happen is, if it's an incident at school, a school police officer is involved. They charge the child. Sometimes they physically arrest them, place them in handcuffs. Sometimes they physically tackle them to the ground. They can remove them from school and only notify their parents after the child's been removed from school. The child can then be taken to the police station where they are held until they're either released to their parent or the Department of Juvenile Services is called and authorizes detention. If they're released to their parents, they're charged on a piece of paper. They then have to go to the Department of Juvenile Services for an intake hearing. And then if that case gets forwarded to court, if the Department of Juvenile Services authorizes a formal petition, they then get served with paperwork as a sheriff coming over to their house and serving their parent with official paperwork. They have to come to court. The first time they come to court, they're not represented. They're just with their parent. And then their parent applies for representation, and that's the point when I get involved. If it's a child who was detained, detention was authorized by the Department of Juvenile Services, then at that police station, the Department of Juvenile Services was called, an intake officer authorized detention. The child is then brought to a juvenile detention facility. While there are limits right now on very young children being brought to juvenile detention facilities, it still does happen. Then that child has a detention hearing before a judge the next day that the court sits. So they are at a minimum spending a night in jail, in a juvenile detention facility. If it happens to be a Friday when this happened at school, they're there over the weekend.
Thank you.
Thank you very much, and thank you. As I was listening to you talking about the process, the one thing that I wondered was, for most of those incidents, one would think that the principal would probably just take the child and explain that you don't do those sorts of things rather than making a criminal case of it. But what you're saying is that doesn't seem to be the case. They're actually making a criminal case out of it rather than just dealing with it and correcting this bad behavior.
I am sure there are many incidents where a child is acting like a child at school, where it's dealt with by the teacher, by the principal in the school. The problem, though, is the cases where that doesn't happen. And those are the situations that I'm talking about. Those are the situations where squirting orange juice at a girl that you like in middle school gets charged as a second-degree assault. And sometimes that's because there's a school police officer in the school, which is not what we're here for. Sometimes that's because the other student's parent is pushing the police to charge. But either way, we're talking about very young children being charged for something that many school principals and many teachers and many parents would deal with on their own. And I had a client recently who the parents did in fact try to deal with it on their own. She was charged with an incident related to a neighbor. Her parent walked her across the street to the neighbor. She apologized. They reconciled. She was 11 years old at the time. They were playing. She and the neighbor's child were playing together every single day. They celebrated birthdays. They celebrated Halloween together. But she still had to come to court because the state's attorney decided to go forward with the charges. So every day she's going over and playing at this kid's house, but she apologized. And a year later, she's still coming to court dealing with an incident that she has no memory of because she's 11 years old.
Thank you.
All right, see no further questions. Thank you very much.
Thank you.
All right. And with that, that'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel and Mr. Katzif. Welcome.
Good afternoon, Mr. Chairman, members of the committee. My name is William Katzif. I'm an Assistant State's Attorney for Anne Arundel County, here on behalf of the Maryland State's Attorneys Association in opposition to Senate Bill 691. I'm going to focus on a couple of things. They were touched on in the course of the presentation by the proponents. Number one, the age in which a juvenile court can assume jurisdiction. We begin with the premise that you have to be at least 13 years old, unless it's a particular offense that's listed on pages 2 and 3. Now, there are any number of offenses that are not included that would prevent someone under the age of 13 from being prosecuted. Second-degree assault. Now, they talk about low-level misdemeanors. Admittedly, second-degree assault is a misdemeanor. But unless we get to the point where we can show that the assault was committed with the intent to cause serious physical injury, which elevates to a first degree, it's a second degree. I can assure you, I screen a lot of cases, not juvenile cases, and there's some pretty nasty assaults, but just do not reach the threshold in order for it to be a second-degree assault. How about attempted first-degree burglary? That would not be included here, even first-degree burglary. How about second-degree child abuse? That would not be a crime for an offense for which someone under the age of 13 could be charged with. Now, the second part of my concern is with regards to incarceration. On page, I think it's page 12. And that is, unless they're found delinquent for a particular type of offense, they cannot be incarcerated. They cannot be placed in a juvenile facility under the jurisdiction of the Department of Juvenile Services. There are any number of offenses that are misdemeanors that are pretty serious, and no misdemeanor unless it's with a firearm. Now, I can assure you there are a number of misdemeanors that I screen, I don't elevate to first degree, that involve weapons, not necessarily firearms. Firearms are automatically a first degree. But there are any number of serious offenses that are classified as misdemeanors. Attempts, short of attempt to commit a crime of violence, would be a misdemeanor. Now, I just don't think what's contained here with regards to the threshold for juvenile court jurisdiction really makes any sense. And for that reason, I would urge the committee to give the bill an unfavorable report. Thank you.
Yeah, I just have a quick question. I'm curious of the testimony because when I talk to my state's attorney, they say basically they're not really involved to the point where they're, I'd say almost, I don't want to speak for them, but it's almost concerning that as far as charging things in schools or when things happen in schools, it doesn't seem like they're told when assaults or thefts or things like that are happening within the schools. It's certainly been reported in our county that there's been violence and things that the state's attorney was never told about. And I find the testimony today was that, well, these prosecutors are going in charging people for stealing bags of Doritos in schools, and for having 3 kids in the school system, that seems the exact opposite of what I'm seeing.
You know, I'm glad it was fleshed out, the fact that the police charging does not necessarily mean formal charges. They can be closed at intake, and any number of cases that are charged and closed at intake, I would never see, or I don't see any juvenile cases for that matter. Our juvenile state's attorneys do not see.
I guess my question is, I mean, I'm just curious, since you're here, you're in Arundel County, I mean, how involved is the state's attorney or even the police in charging of school incidents?
Well, the police might be the one to charge when it's reported to them. Then again, it goes to an intake officer. Okay, it may be closed at intake. If that's closed at intake, we wouldn't know anything about it.
You don't really know then.
Right. We don't have the authority to appeal a decision of the intake officer. If it's an offense where there's a victim, then the victim or the victim's parents can appeal, and then it would be brought to our attention. We do not have the authority to appeal a decision of the intake.
Yeah, I guess what my question is then, it doesn't sound like you deal with this part of it, is I'm trying to figure out, because we have this, in my mind, a discrepancy between we're having bills on the floor, people coming in here, and maybe it's different in other counties or jurisdictions. I don't know, but from what I'm seeing in my jurisdiction it's the opposite. We have a problem with school discipline, we have a problem with assaults and violence in the schools, and no one's being prosecuted, no one's being threatened, or no one's being punished in the school, and there's no accountability. And then we get these bills to hear that it's the exact opposite, that we're 1980s, zero tolerance and all this stuff. And it's not matching up with what I see as a parent or in my school system. And I guess I'm trying to figure out, are there other jurisdictions that are doing this, or are we getting misrepresentation? I guess that's my frustration.
You would probably have to get the information from juvenile services with regards to how frequently cases in the various counties are sent to the state's attorney for formal action, and how many are closed in intake, both in terms of numbers, in terms of percentages.
Okay, I'll ask for that. Thank you.
Thank you, and good afternoon.
Good afternoon.
You had mentioned, you said that the state's attorney has no authority to appeal an intake officer. Could you explain that a little bit for me?
Well, if a case goes to, as a charge, and it goes to intake, let's assume that it's an assault or a theft or something like that, and the intake officer closes it at intake, okay? I think the police officer might be able to, but don't hold me to that. The victim can. The state's attorney cannot appeal a decision and ask that it be brought up for formal disposition.
And why is that?
No, I don't know. It's just what the law is.
So it takes a law to change that?
Yeah, it would take a law to change it, yes.
Thank you.
All right, with that, seeing no further questions, thank you very much.
Thank you very much.
Thanks. All right. With that, that'll conclude the testimony and the hearing for Senate Bill 691. We'll now move on to Senate Bill 785. We'll start off with Ms. Gruber. Mr. Bishop.
Mr. Chairman, with your permission, if I could bring up the rest of our team from DLS working on this project, Michelle Davis and Dr. Jasmine Bailey. So thank you. So this bill is pretty straightforward request for information so that we are able to prepare substantive and informative racial equity impact notes. This initiative began in the 2020 interim when the presiding officers asked DLS to undertake a pilot project looking at how we could produce these notes, particularly with respect to criminal justice legislation. There had been legislation proposed in the General Assembly that hadn't passed over the prior several years, proposing this kind of initiative, and presiding officers asked us to look into that. I did a lot of research during that interim on this project, and it really varies from state to state in terms of how they do it, what's available, and what they produce. In only 3 states, they produce, their legislative staff agency produces this kind of a note. In 2 of those states, New Jersey and Connecticut, although there's a requirement on the books that they do this, in 4 years they had only each produced 1 note. And the 3rd state, let me look at this, Iowa. Iowa produces it on a more substantive basis, but it's really just about demographics of their prison population. So if we were to undertake this project, we wanted to make sure that we could do it in a way that would be substantive and informative to your decision-making process. We ended up contracting with the University of Baltimore Schaefer Center and Bowie State University to assist us in this initiative. Michelle Davis, who now is the manager of the Racial Equity Impact Note function, and Ryan Bishop, who's our director of the Office of Policy Analysis, played a great role. And then we were able to convince Dr. Jasmine Bailey, who was finishing up a fellowship at the University of Maryland College Park, to work with us as a pilot part of the pilot project, but then also to come on board full-time as an analyst with us during the 2021 interim. So we're very happy to have him on board. This bill came about as a function of our beginning this project, which really was a realization that there's not substantive, consistently collected available data for us to do these notes in the way that we would like to do for the members of the General Assembly. And so during the 2021 interim, Michelle convened a group of analysts to look statewide what kind of information and data we would need to be able to produce these notes for you. And this legislation is the product of that work. So with that, I'm going to turn it over to Michelle to talk briefly about how they came about this legislation. The only other thing, that I will say is we did, Michelle has been working with the state police who had some concerns, and she's trying to address them. So we're happy to work with you and the various stakeholders on this legislation. So thank you.
Great, thank you. Vicki pretty much said it all, but I will add that I have been talking with the state police regarding the bill, and we have worked on a friendly amendment that will be forthcoming. And I believe all of the other agencies, there were no issues. And what we tried to do this year was to basically facilitate the data transfer. In other words, we already know what data that they're collecting, and we simply want them to get it to DLS in a format that we can look at it and statistically evaluate it. So that's why we needed the raw data, so to speak, or disaggregated data, as the bill says. And that's about it. Thank you.
I don't know, Brian, did you want to add anything?
The only thing I would add, good afternoon, members. The only thing I would add is data collection is really the biggest hurdle we have to being able to do more of these nodes and to be able to do higher quality nodes. So to the extent that you can help us in passing some version of this bill, it would be greatly appreciated. Thank you.
Dr. Bailey, I don't know if you want to say anything.
Okay. Unless anyone else had, Doctor, do you have?
No, I'm good.
Okay, great. Senator West, and then we'll go to Senator Castley.
Thank you, Mr. Chairman. We've had a number of these bills in the last couple of days asking that information be supplied. Recent bills requested information from the Office of the Courts, Judiciary. And so here we have more information. It all seems very similar in a way. The judiciary information is about cases pending in court. This is about cases where people are charged. I'm wondering whether it wouldn't make sense for us to put together some sort of a summer work group with all the people who are advocating for more information, as well as the people who have access to the information, and get everybody to work together to come up with one comprehensive bill which would not require the same information to be exchanged back and forth between departments, which just seems to be a lot of useless effort. What do you all think about that?
Well, we thought this bill is a starting point for us to be able to produce these notes. The most information that we could request, given what's already being collected. But we would certainly welcome an opportunity to get more data, to expand what we can do and what we have information to provide to you. So, you know, including the judiciary, state's attorneys, other groups that are part of the criminal justice process, we would certainly appreciate the opportunity to ask them to provide data as well.
Hi, thank you all for coming in. So I'm just curious, I don't see anything here about collecting information on the victims. Am I missing something? I mean, if we're looking at racial data, it seems to me that it's just as important to show victim information as it is the defendant information.
Yeah, I can answer that in part. This legislation was just a starting point to get agencies to begin to give us the data that they already collect. And if my recollection is right, the UCR does have some limited victim data. And the way the bill is going to end up to be written, it's going to include everything that is currently reported in the UCR, because that is what they are collecting right now.
But this is by incident, right? Is this just gross numbers? How will this be? Just by jurisdiction? When you see this report, it's going to say by county, by individual? How will this be?
Well, that's another loaded question. Right now, the UCR, the data collection is in flux. In other words, they're going from a summary aggregate system to an incident-based reporting system, but most of the local agencies are still in the process of changing from aggregate reporting to the incident-based reporting. So we don't want to mess with that, because that's the federal government, federal system that they're trying to comply with. So we are just looking for what they already have. So some of their data is incident reported and some of it is aggregate. But right now, in the whole, the Maryland UCR is still reported in the aggregate. So we're asking for the data as disaggregated as they can make it at this time.
But is most of this data, is all this data already being collected?
Yes.
What about, I mean, we say on the offenses in domestic crime, household status and relationship, associated crime, alcohol or drug involvement, circumstances, Is that data being collected already?
Yes, that is all currently reported in the UCR.
But it's not being tied. I mean, look, I'm a big proponent of bringing in data, but it ought to be useful. And it seems to me that if you're listening to the last bill, what really matters is trying to draw correlations between the defendant and the outcome. And so, was this to say that a percentage of the defendants are fourth grade education and a certain percentage, I don't know how valuable that turns out for us, because what's really valuable is tying those demographics to the crime. So how many defendants who didn't graduate from sixth grade are involved in violent crimes, which would indicate that education is an important thing. And how many defendants who are violent crimes are tied in with, as you put over here, drug and alcohol abuse, household status, associated crimes, juvenile records, trying to draw some more pictures. Otherwise, we end up with something that just says,
Yeah, I definitely understand.
I'm not finding utility of this in the end for policymakers, because and what I've learned, because I really worked hard on the whole data thing, it became very frustrating to me over the last 7 years. The challenge is getting them to collect it in a way that is usable. And if you they spend money on that. If your computer system says this right now, it may cost you $250,000 to add in. We're like, hey, just add in a few more fields. And they're like, well, okay, with all due respect, that's not so easy. I got to hire a contractor to come in and do all that and change the input data and change the computer forms. Back to what Senator West was saying, these are huge lifts for a lot of them to collect this data in a usable format. So it really kind of gets down back to his idea of what is it we're looking at? Because I think just saying how many African Americans, how many Caucasians, how many Latinos, or whatever, but if I can correlate that into, because we want to be able to say, go back to those root causes. I got it, you committed a crime, okay, but we want to get back and say, well, this shows that people who didn't complete third grade, or people that went to this school, or people in this neighborhood, or people with drug abuse, drug abuse issues. So then it lets us as a legislative body determine priorities of spending, of funding, gear it towards, I got a problem in this neighborhood. If we can flood that neighborhood with services, then we can reduce the crime rate substantially on that neighborhood. Or that if we can put more educational resources into that school, let's pick, instead of education, let's look at the problem schools and say, this school, half the population's in the DOC. Whoa, we're spending $1 million to keep in the DOC. Let's take that $1 million and put it into the school. So it's that kind of wraparound I think we're really looking for, and just sort of collecting data to say, oh, look, there's more of these, there's more of those. As a policymaker, I just don't I don't see the benefit for it, honestly. Right? Anyway, thank you. These are challenges, and they're very difficult challenges, but when we push out demands to say collect data, just got to appreciate that we're saying over here collect data, over here collect data. It needs to be composite, because this stuff is expensive, and that was the thing I learned the most about going down this, which is how difficult it was, because I thought, well, just add a field. Senator, it's not so easy to add a field. We're collecting data all over the state, and here's our collection process. It's got to go, and we don't do that. We contracted these brilliant computer sciences to have to come in here, and they're on a contract. You have to add another $1 million to the contract. It's just challenging. Senator West's point on the summer study really makes a lot of sense to me, but thank you very much.
This is primarily information that is already collected by, you name an agency, that you're asking them to disaggregate it to an extent. You're going to get this in one central repository. You've hired a staff, putting a team in place to figure out what all that means. And if there's more information that we need, we can come back and we can ask for that. But I think this is a good start. And we've got brilliant minds ahead of us that you'll figure out how to put into some digestible, useful form for us. But or so we hope.
Mr. Chairman, the only thing I would say in response is, we do fully expect this activity to expand into other policy areas. Whoops, I'm sorry. We do fully expect this function to expand into other policy areas, looking at disparities, as you said, in education, healthcare, housing, and other areas. So that we anticipate expanding to that degree, but for now, Jasmine is our only analyst right now in this function. Michelle is the manager. We have 3 positions that we hope to hire this session to expand even further. So this is a starting point. It's not the ending point, but it's a starting point. And as Senator West mentioned, we would welcome any efforts by the General Assembly to get us more data to give more substantive information to you all.
Longitudinal data, forget the longitudinal, what's it called? The
Data and systems analysis, I always mess that thing
yeah,
up.
college, it's based in College Park. Do you have access to them and what they do?
Yes, yeah.
I mean, I was very impressed by what they gather and their ability to gather and the breadth of which they're gathering it. I just wouldn't want to be repeating stuff that maybe they're gathering, so I'm hoping you're coordinating with them.
So yes, but they do lack a lot of fields that we need, like in terms of the UCR data. But I do think comprehensively, if we wanted to look at institutions such as education and criminal justice, that is excellent and isn't an excellent route to go by. But right now, with the disaggregated data, we could probably do certain things with various agencies to kind of have a more comprehensive assessment.
And I know they have certain statutory restrictions on being able to disclose certain, I would hope that if that's an impediment to you all, that you could come to us with emergency legislation, because if you don't have access to data they're already collecting in a very usable format, see, I think that we could simply a statutory correction to say, because they're very tight on, if it's not in the statute, sorry, we can't talk to you. So if that's an impediment, I would hope that you all would be approaching us, because it's just
been a lot of
statutory.
the problems. So yeah.
Okay, thank you.
Or what we just did with them, right? I mean, they just created an MOU with the bill we have before us. No, I hear you, but I'm saying, I get it.
By law, and sorry, you know this, statute, we can't disclose to you. So if that's an impediment,
No, I got
these
it.
guys ought to have access to that stuff. These gals, the guys.
We were putting stuff into legislation, and then they went ahead and brokered a deal and did the MOU. So I think the Spectre legislation probably forced that, but yeah. Okay. Senator Hedelman.
Mr. Chairman, Vicki, the purpose of this is to one of the main purposes is to enable you guys to do these racial equity impact statements. And I know that's a new thing, and maybe not everybody has had a chance to really see them and review them. And I was just trying to find a bill that we could look at that, so everybody would be on the same page with knowing how this data would be used. If there is a bill that comes to mind that you could refer us to, that everybody could look at that would be really helpful,
We've done one on House Bill 1.
Okay.
Which is the cannabis. Legalization referendum, and then there's a corresponding Senate bill, I believe it's 833.
Okay.
Senate Bill 833.
Great.
That we did one as well. And then last session, we did a number of bills, including an omnibus one on all the various police reform bills.
Great. I think, a number of years ago on the other side, I worked on some of these issues, and I commend you for moving us in this direction. I think it's really helpful, and I think it will be helpful to have your guys' analysis of the impact of the legislation that we're putting forth. So thank you.
Well, and we, while it's a challenge, we also, are viewing it as a real opportunity. This is the first new function DLS has done in I don't know how many years, at least 30, at least 30 years. So it is quite an undertaking for us, because if we're going to do it, we're going to do it right.
Right, and I know you're starting out on the criminal justice area, but actually I would hope, that you would broaden it eventually.
We anticipate that happening, yes.
Great, thanks.
It's exciting to see the impact note tab on their laptops. It's kind of cool. So yeah, I think the summer study idea is a good idea, but it seems this would be front loaded. So you do this first, we'd get to see how this is going, and then we could do a summer study to figure out what may be more effective afterwards. But okay. See no further questions. Thank you all very much. Thank you for your patience today.
Thank you.
All right, with that, that'll conclude the testimony for Senate Bill 785. We'll now move on to Senator Huff with Senate Bill 703.
I'm not sure if Michelle's here from the Lake Linganore Association. Come on up. Well, this should be a simple bill. Thank you for moving it up, Mr. Chair. This is a similar bill to, actually, it's completely modeled off of legislation that the committee has done in the past. We did it for, I know Senator Eckert has had bills like this. It's just enabling authority for the counties to deal with the golf cart legislation. And so this is for the Lake Linganore Association, which is a community in Frederick County that I represent. It's pretty simple at that. Basically says that puts in place safety regulations, use of golf carts, including driving only on roads where the speed limit is under 35 between dusk and dawn. Golf carts are equipped, lighting, driver must be licensed. It's enabling authority for the county And Lake Linganore Association is already using these golf carts. That's why we're trying to put this in place so we can have good regulations in the county and on the use of them. And I'll turn it over to Michelle. Michelle, if you want to step up here.
Good afternoon. Thank you for the opportunity to speak to you today. I'm Michelle Doster. I'm the General Manager for Lake Linganore Association. Lake Linganore, if you don't know, is a vast community spreading over 3,200 acres in Frederick County. We have approximately 4,100 homes now and estimated to be at about 6,400 at completion. Since its inception in 1968, Lake Linganore has been a golf cart-friendly community, and we have many, many golf cart owners within our community at present. So as such, we do support Senate Bill 703 that would delegate authority to Frederick County to produce legislation to allow golf carts to travel on roadways within the county. Thank you.
The year of the golf cart. All right. Thank you very much. Thanks to you. No further questions. That'll end the hearing for Senate Bill 703. We'll now move on to Senator Kagan, who's just arrived. Senate Bill 684.
Oh, man, I walk in and the chairman walks out. That's a really bad sign. Okay, I'm feeling the love, Mr. Chair. Good afternoon, colleagues. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. And we should make this a fairly quick bill. This is here for the committee to hopefully incorporate as we think about legalizing cannabis. Timing matters. Timing is everything, as they say. I brought this bill to you all in 2016, and the former chair didn't think it was quite ready for prime time. In 2017, I brought the bill back, and he still wasn't ready, and that was with his permission. He still wasn't quite ready to deal with it. So in 2020, Senator West and I brought a version of this bill, and you all passed it. It passed the Senate. It passed out of this committee. Unfortunately, it was basically on sine die. So what does the bill do? It used to be a pilot program to start to figure out how we can use technological advancements to identify people who are driving under the influence of drugs. As this committee knows better than any other, there is excellent technology and a variety of tests that are available for driving under the influence of alcohol. Our laws are broad and deep, and while certainly Noah Liata's family and others want them to be even stronger, they often are effective. As we have legally expanded access to and use of in Maryland, the use of recreational, medicinal, and then prospectively recreational cannabis, we are not yet incorporating legally available technologies that are being used in other countries and other states. So I want to bring this back to you. I just want to say that we took out the pilot project portion of this bill because I don't think there's time for that. 26 other states have already started using this technology. Maryland is lagging behind, and we are having impaired drivers on the road killing themselves, other drivers, and pedestrians. So the reason for this hearing and the reason why this is going to be somewhat brief, and there is written testimony in your folders, we are imploring you, as you think about moving forward with cannabis, please let's not create an opportunity to put more impaired drivers on the roads. So let me just give you an idea. Over the last 5 years, according to Zero Deaths Maryland, over the last 5 years, nearly 800 deaths in Maryland are due to impaired drivers, and that's nearly 1/3 of all traffic fatalities in our state. Rocky Mountain High Intensity Drug Trafficking Areas 2021 report, when they looked at legalization in 2013 until 2020, traffic deaths where drivers tested positive for marijuana increased 138%, while all Colorado traffic deaths increased 29%. The last statistic I'm going to share is the California Office of Traffic Safety reports. In 2018, 42% of all drivers killed in motor vehicles crashes who were then tested were positive for legal and or illegal drugs. Again, 42%. So we are using the field sobriety and breathalyzer tests. There are 103 cannabis dispensaries. I think that's still the right number in Maryland. I think that as we look to possibly expand for more availability of cannabis in the state of Maryland, we want to give our police officers another tool. And so, again, I just want to give you the idea of the range of, with 26 states. They range from Alabama to Michigan to Indiana and many, many others. I have with me Officer Jamie Derbyshire, who has been a police officer for 20 years and a DRE, a drug recognition expert, since 2008. Her expertise is widely known and respected, and she speaks at national and statewide conferences, and I'm grateful that she took time to come and join us today. So if I can toss it off to Officer Derbyshire. Thank you.
Thank you, Senator Kagan, and also thank you to Senator West for being sponsors for this bill. Good afternoon, Vice Chair and members of the committee. I appreciate the opportunity to speak before you today. I am Jamie Derbyshire, an officer with Montgomery County Department of Police and a certified drug recognition expert. Montgomery County Department of Police asked for a favorable report for Senate Bill 684. This bill is working to establish legislation that allows for law enforcement to request for a subject suspected of driving under the influence of drugs to submit to an oral fluid test. According to the National Highway Traffic Safety Administration, impaired driving kills over 10,000 people per year in our nation. While alcohol is the most common cause of impaired driving, drug driving is currently on the rise. The National Survey of Drug Use and Health in 2020 reported that 12.6 million people drove after using illicit drugs. Of that total, 11.7 million were under the influence of cannabis. I certainly don't mention this to single out cannabis-impaired drivers, for we know that any drug-impaired driver is a threat to public safety, but I mention it because I think that it is particularly relevant to Maryland. We need to protect our roadways from drug-impaired drivers no matter the substance. We also need to prepare for what full legalization of cannabis may look like, and we need to be accepting of all aspects of that picture, not just what may be considered the positives. We need to address the impaired driving aspects and consider that there will be deaths due to impaired driving as a result of this legalization of cannabis. One only needs to look to Colorado, Washington, and California to know this very real truth. By allowing law enforcement to request for a subject to submit to oral fluid testing when suspected of drug-impaired driving, Senate Bill 684 is implementing proactive and protective measures into highway safety. Oral fluid testing is a non-invasive method that provides fast results and is indicative of current drug use. The implementation of this testing method will not change how officers determine if a driver is impaired by drugs, but will provide an additional tool to assist in the decision-making process. Australia and much of Europe use oral fluid testing. Currently, over 26 states in the U.S. are using it as well. In preparation for the complete legalization of cannabis, the Canadian government passed legislation allowing for the use of roadside oral fluid screening devices. Oral fluid testing is becoming more and more commonplace throughout our nation and throughout the world. Please assist in helping Maryland to combat drug driving and provide safer roadways statewide. Montgomery County urges the committee to adopt a favorable report on Senate Bill 684. Thank you so much.
Thank you, Officer. Excuse me. Questions for this panel? Senator Castley.
First, good to see you back again. The first year of the last year order was you brought in your equipment and you gave a little more in-depth explanation. And I'm just curious, is the science evolving much, or is it pretty much static, or improvements in accuracy and the like?
Yes, sir. Thank you for your question. It definitely is. I have some notes just on some of the basic manufacturers and kind of what we're looking at. The nice thing about the science right now is, as far as accuracy rates, it depends on the drug category that's being tested on the panel. So these panels can be modified through the software so that we would only, if Maryland only wanted to test for, say, cannabis and opioids, they could do that. And that could be limited. And so we could pick, accuracy ranges that are most applicable to the state, but also most reliable. So what they've seen with regard to accuracy ranges are 89% to 100% accuracy rate on these devices.
Well, what if it's just cannabis? Is that 89 to 100%?
No, it's for just cannabis, it's even higher. So that kind of factors in the whole drug panel. So benzodiazepines tend to have a lesser accuracy rate, that could be left off. Cannabis is close to 99.9% accurate for oral fluid testing.
Okay, thank you, officer, appreciate it.
Yes, sir.
Thank you, Mr. Chair. Question for the officer. So this is one of the things that is most concerning to me because for some reason I just see pictures in my head of recreational marijuana and black and brown kids being pulled over each and every day. And the challenge is that even though you have the ability to test for marijuana, we don't yet have a level analogous to alcohol when somebody is impaired. And so based on what I know now, I can smoke a joint, hit it one time, subject myself to an oral fluid test. Would that show positive?
Well, there are thresholds depending on the manufacturer, so it has to have 25 nanograms for most of these. That's their threshold for cannabis specifically.
That's to be detected.
It does. So if you were under that threshold, so one hit off of a joint, prior to, is not going to meet that threshold.
So unlike alcohol, where somebody can be thin, somebody can weigh 300 pounds, where we know what that 0.0 whatever it is level is, we don't have that for cannabis at this point, correct?
That is correct, and we would be going backwards if we did have levels, to be honest with you, because it's very individualistic to the person. So similar to your tolerant alcoholics, there's people who consume, some of our medical patients that consume every day, and their levels are generally going to be higher. But just kind of in response to your question, and maybe to perhaps provide you a little bit more reassurance, is this legislation, it mirrors our current preliminary breath test law. So, and that law has been in effect since 1980s, I believe. And so our stopping procedure with regard to, observing a vehicle, looking for signs of impaired driving and, weaving and swerving and all that stuff that we generally look for, that's not going to change. And this legislation isn't going to change that either. And it's not even going to change, once we stop that vehicle, if we have any indication that the person is impaired, the first suspicion is always alcohol because that's most common and that's how we're trained. And so we want to rule that out before even getting to the drug aspect. So we would still go through standardized field sobriety tests. There would have to be observable impairment before we would even offer a roadside screening device, which is what we do with the preliminary breath test. We have to have that observed impairment by the officer before we give them a preliminary breath test for alcohol. And the same would be said for oral fluid.
Right, and I just think this is a real slippery slope we have to be careful about because recreational marijuana gets legalized, you're going to smell it each and every day. And if I'm a public safety officer who has been trained to notice this, I'm going to raise my awareness, and there has to be a whole education piece wrapped around this, in my opinion, because we don't have, so define for me, impairment level. You do a couple other things on the side of the road other than the oral fluid.
We do.
What other things would guide you into going past, I know this person has marijuana in the system, but this person is impaired to the point they pose danger to other people?
So you would need to see some kind of cognitive impairment and then some kind of impairment that is most likely displayed on a roadside test. So if you were asked for a license and they hand you a credit card and then they follow it up with something else. I mean, people are generally nervous, so that happens.
Yeah.
But you would need, additional factors beyond just one thing to show that there is some lapse in mental capacity that could potentially be, influenced by drug impairment.
Yeah, and I agree something is needed, and we'll probably have to revisit this, but I can see recreational marijuana being legalized, and now we have to look at people's profession, industry by industry. I just don't see how recreational marijuana jives with those who carry firearms, those who have to operate heavy machinery, those who have to use fine motor skills like doctors in their daily professions who take other people's lives, under their peace. I've been told in no uncertain terms when I was in the military, we don't care what the federal government does, you cannot do this. As a top secret clearance holder, you cannot do this. And so, I just hope we can continue to work together because we know this is coming. And I thank you for bringing forth the legislation, Senator.
Thank you.
Senator Bailey.
Thank you very much, Officer. So what I was going to ask you, there is no level of, when you do this test, you can't tell how, and like there is with BAC, you get a BAC reading, and you can tell how that level is. Can you do that with marijuana, or is it just positive and negative?
No, sir, you can, and it would actually be a hindrance to us to put a number on it because some people really aren't impaired at a low level, with regard to cannabis in their system. I mean, as an officer, I kind of hate to say that, but that's the truth. It's the honest truth is that, there are people who use regularly in the way that this drug is metabolized through our system. It stays in our fat as opposed to alcohol that's attracted to water. And so it sticks around for a little bit longer, not in oral fluid, which is what makes this so unique, but in our fatty tissues. That's why urine tests show positive for cannabis for a very long time because of that. But honestly, there's people who use every day that would have higher nanogram levels in their body, and for driving purposes and sobriety purposes, they are fine. And that's really where that observed impairment is so important and needs to come. And this would just be a tool to help supplement, but it's certainly not the end-all solution. Unfortunately, I wish it was, but it's not. It would just be a tool to help supplement observed impairment.
So this is going to be utilized in coordination with the whole battery of approved field sobriety tests?
Yes, sir.
Okay. And so when you say it falls into the line of the preliminary breath test, right? Now, the preliminary breath test, years ago when I was a police officer, couldn't be used as any type of evidence against them. It was just a tool for the officer.
That's correct, sir. And it's in that legislation as well that this is going to follow suit with that.
Right. That's what I was trying to get to, that this wasn't going to be the end-all, do-all, right? This is just a tool that is being provided for you as an officer to be able to help if you come up with bad field sobriety tests, you give them a PBT, it comes up 0-0. This would be another alternative that you could look at to try to gain other issues. Now, did I hear correctly, are you a DRE?
Yes, sir.
Okay,
Yes, sir.
so you're already trained to look at their eyes and observe different levels of possible intoxication based on drug use.
Yes, sir. I am, but there's a limited number of us, and so this would probably be, it's easier for me to go make a traffic stop and be able to ascertain that with any additional tools,
What?
but not everyone.
I understand the process, because a long time ago, I was a DRE, right?
Very well.
So I do understand the process. One other question that I have for you, and I haven't been out there for a while, but, I've worked a lot on boats. So if we had a boat accident involving a boat where there was any injury whatsoever, automatically the operator of that boat was required to get a blood test. Not a test by breath, but it was a blood test. Took them to the hospital, and they were required at that point to do that. We don't have that in the motor vehicle law.
No, sir, there's, we have an implied consent law, but based on that recent Supreme Court ruling at Birchfield, it now generally requires a subpoena in order to obtain a blood specimen for intoxication determination.
Right. Okay. Thank you.
Thank you.
And thank you for what you do, officer. We
Thank you,
appreciate
sir.
it.
Thank you.
Any other questions for this panel? Well, I too would like to thank you for your service to our county and our state, and thank you to the sponsor for bringing this bill. I believe that completes the hearing on Senate Bill 684. It does indeed. Thank you again.
Thank you.
We'll now move on to Senate Bill 701. Senator Klausmeier.
Good afternoon, Mr. Vice Chair and members of the committee. Senate Bill 701, Vehicle Laws, Window Tinting Materials, Private Detectives. Senate Bill 701 would exempt vehicles owned or leased by private detectives from the prohibition on using certain aftermarket window tinting materials. Ending the prohibition on aftermarket window tinting will provide additional safety as well as practical features to the profession. Communities may be on high alert when seeing an unfamiliar vehicle in their neighborhood. These additional eyes may prevent private detectives from effectively performing their duties. Private detectives often carry expensive equipment, and window tinting could deter would-be thieves. In addition, tinting provides additional cooling and UV protection for the agents, which is especially important for private investigators who are accompanied by search and rescue or drug dogs. Put simply, Senate Bill 701 would allow private detectives to tint their windows to help them do their jobs. I would like to thank the Judicial Proceedings Committee for their consideration of Senate Bill 701, and I am requesting a favorable report. And I have my panel here, so.
Good afternoon. Thank you, Senator Klausmeyer, Mr. Chairman, distinguished members of the committee. My name is Pat Gibbons, and I'm a loyal MESA member. I was formerly a law enforcement officer for 31 years, and also with the Maryland State Police and the Federal Bureau of Investigation. I'm here today to support this legislative 701. It protects Maryland investigators and security members, particularly those folks that would be impacted from a safety standpoint. The safety impact to investigators working in areas where lone individuals, whether they be male, female, those opportunities could result in a tragic ending like the one we saw recently in a Baltimore City police officer. Window tinting helps reduce temperatures also inside the motor vehicles, and it's especially helpful for those private investigators who have search and rescue animals within their motor vehicles. MESA has been working very constructively with the Maryland Department of Transportation and the Motor Vehicle Administration, as well as the Maryland State Police representatives, to develop a flagging system in the near future to also enable law enforcement to identify licensed private detective vehicles. I and MESA urge you to give favorable report to SB 701, and I turn it over to MESA Vice President of Investigations, Ms. Caitlin Kelly.
Thank you. I think because of the way our camera is aimed, we prefer people testify from the podium.
You want that?
if
Yeah, I
possible.
thought
Yes,
maybe- yeah,
please. Thank you so
yeah,
much.
You're fine. Could you could see it? Am I all right? Okay. Okay.
Hello, my name is Caitlin Kelly, and I am the Vice President of the Maryland Investigators and Security Association, and I also own a private investigative agency. I live in Owings Mills, the area of Senator Hedelman, and I proudly have my office in the historic building, the old Baltimore County Jail in Towson, the area of Senator West. So I'm here today to express support for the Senate Bill 701, which would allow exemption for licensed private investigators to have the dark window tint. This is, the darker window tint is essential for private investigators to do their job safely and effectively. And in the interest of time, I'm going to share just one personal experience that I've encountered. There's been many, but as to how this has helped, not only help me do my job, but keep me safe. So while doing surveillance one day, and by the way, I do have the darkest tint, 5%, on my side and back windows, and I put up the sunshade across the front windshield so nobody can see that I'm in that vehicle. It looks as though nobody's in there. The vehicle's turned off, and that's how it should be when I'm doing surveillance. Now, what happened was about 6 adult men start congregating around my vehicle, recognizing this is an unfamiliar vehicle and want to know who's inside, if somebody's inside, and why this vehicle is there. They actually were pressing their face against my vehicle trying to see inside. And you can imagine the fear I had in the back of my vehicle, like, oh my gosh, I hope they don't see me. This could be bad. Eventually, they dispersed because they could not see me, and they lost interest at that point. And I know for certain that that window tint was what made it possible for me to effectively do my job that day and keep me safe. If you don't mind, I just want to also share that I have been pulled over multiple times for having this dark window tint, and I luckily have been let go because the police officer understands the reasoning for that. However, the problem is I'm at their mercy, and what if they don't understand? And then I would have to have a repair order to have that removed. So an exemption from the window tinting regulations for private investigators is just a small step that will go a long way for our protection. This has already been passed in Massachusetts, Georgia, Florida, and Tennessee, and hopefully now in Maryland.
Thank you,
And I
Ms.
want to thank the committee and urge you to give a favorable report.
Thank you so much.
Vice Chairman, honorable members of the committee. My name is Paul Bressler. I live in Havre de Grace in Harford County, Maryland. I've been a licensed private investigator for 21 years. I own a private investigation company named Castle Security Group. It's located in Middle River in Baltimore County, Maryland. The bulk of my clients are law firms in downtown Baltimore, and my service area is the full state. Surveillance is an important part of my business, particularly in personal injury fraud cases. Things changed after 9/11 and the DC sniper attacks. We're now in the era of see something, say something, and surveillance vans stand out. More so in residential areas where there may be schools, daycare providers, or the like nearby. There are things my company does to try to anticipate this. We always notify law enforcement if we're going to be in the area that day. My agents are instructed, if they're approached by a member of the public, identify themselves. However, there's a segment of the population that will not approach us, and rightfully so. They simply call the police. And when the police are called, they have to respond. This is a waste of police manpower. It is a waste of taxpayer money. And it may end up that the police are talking to me when they could be off somewhere where they're much more vitally needed. In my line of work, being able to blend into a neighborhood is invaluable. And if you look around when you're driving home today, a Honda Accord or a Toyota Corolla with darkly tinted windows is commonplace. It's an everyday sight. This would allow me to do my job, and it will reduce unnecessary police calls. I thank you for your time. I humbly ask for you to approve Senate Bill number 701, and thank you for your consideration.
Thank you so much. Senator Watson.
Thank you very much. Good to see you, Senator. Question, do you think that this bill will actually have the opposite effect you want, whereas law enforcement will pull over vehicles that have the tint and then ask for your identification as, you know, in your field of profession?
If I may, Senator, that's a great question. Yes, it could potentially cause the investigator to be pulled over by a law enforcement officer, and that would be a preferable response. The concern here is, in some of the areas that the investigators are charged to work and serve, not having that tint would potentially set up some aggression in a community where a person is not recognized or they don't know who it is. And that's where the concern is. But, Senator, your point is absolutely correct.
No, I understand. I'm thinking maybe you need one more step, in addition to the tent for protection, but maybe some kind of decal that's only available to folks in your profession that well, you can't do that either, because then folks would know it. I'm just trying to figure out, you know, how else to do it. You know what I mean?
Your point, Senator, is spot on. And so we're working very constructively right now with the Maryland Department of Transportation, and we're also working with the Maryland State Police to come up with some type of designator that falls in line with precisely what you're talking about.
That only you guys know about.
Right.
Got it.
That's correct, sir.
I'd also like to point out, being pulled over, you know, being pulled over, especially, particularly, you know, when we're just driving and not necessarily working, is not the problem in and of itself, because the problem is that we technically would be given a repair order unless the officer is just understanding and recognizes that we're a private investigator, and that's why we have the dark tint to do our job. But they can give us a repair order, and there is no revenue for the state for a repair order.
No. I get that. No, I'm not disputing that. You're doing private investigation. I'm going to assume it's in a not-so-nice neighborhood, a neighborhood that probably has more police present than others. And then I'm going to also assume that if they see a car there tinted, they may want to go and investigate, which would cause more attention being drawn to your car. That's the point I'm trying to get at.
If I may,
Yes.
what I do is practice, and it's not law, but I notify regional police departments in the morning, and and hopefully.
You did say that.
And the other thing that I do is my vehicles that I use are through, my company owns them. So if you were to run my tag, if you're a police officer and you're doing your job, you're going to see Bressler Investigative Services doing business as Castle Security Group is the owner of that vehicle. So in theory, that would help alert. I hope that answers your question,
You know,
sir.
that does.
And I would also like to just
Thank you.
point
So,
out that.
ma'am, I think we try to do
Okay,
one
that's fine.
question, one answer, just
Sorry.
for efficiency's sake,
I
unless.
apologize.
Thank you.
Senator Watson, okay. Senator Sidnor?
Thank you. My concern is just the opposite. I'm not necessarily concerned about police stopping you all, but in some of my communities, we may have those issues of seeing a darkly tinted car that is a strange car and wondering what it's doing in my neighborhood. And I could certainly understand people wanting to investigate. I wouldn't investigate because I don't know if you're up to nefarious things in my community. So, and I've had constituents who have wanted tougher sanctions against cars that have darkened windows. So what would I say to that constituent who does not want to deal with more cars with these tinted windows?
I'll answer that. So that's exactly kind of my point. If we, as private investigators, don't have that tint, I mean, then we're still going to potentially draw attention as an unfamiliar vehicle. But if we have that tint, yes, that's still going to draw attention, but they can't see us inside of that vehicle. Now, that in and of itself is a safety factor.
That doesn't
Do you
make me feel
understand?
any safer.
Okay.
That's where I'm coming from. Not from you all, but for the general public.
Well, that's where they call the police, and if we've called the police in advance, there is no issue.
There's
that
an
can be
issue for the
addressed.
general public that doesn't know who you are.
Right.
That
I hear what you're saying.
That doesn't alleviate their concern that
But
there's
that
a
is a
strange
common
car.
sighting to see dark tint on vehicles all over the place. It's not unusual.
Okay, thank you.
Yeah.
Go ahead.
So I did, just to follow up the senator's questioning, when you're talking about this vehicle that has dark tint on it, and you're going to have previously called the police, and you're going to say, we're working in this area, we're in this neighborhood, and the police call, what do you think the police are going to tell the people?
So, well, I don't know what they're going to tell them. That's
Right,
on
they're
there.
bound to tell them the truth. So
Well-
they're going to say that's a surveillance vehicle or a private investigator right there. So I don't know what you're accomplishing by calling the police and telling them that you're going to be there.
So-
If one of you could help me with that, I'd appreciate it.
If I may. Ideally, that's what would happen. Oftentimes, it simply gets stated in roll call, and it may not ever make it to the street police that are actually responding to us. I just make it a pattern of practice to always tell the police the truth. I don't have tinted windows on my vehicle because it's against the law, and I follow rules, and rules exist for a reason. That's a great question. I really want to think about that. And if it's okay with you, I'd like to maybe write you a letter. Ideally, at the end of the day, public safety is more important than my job, and that's the truth of the matter. And that is why I tell my guys, if somebody approaches you, tell them the truth. We will not say who we're investigating. We'll say, yeah, I'm a private detective, I'm working in this area, and I'll be here for a few more hours, and I apologize if I'm making you. And, we provide them with a business card, they can call us. And unfortunately, if that costs me that case, such is life. I've been doing this for 20 years. I need to do it for 18 more. And I definitely want to give you a follow-up letter if that's okay with you, sir. Thank you, sir.
Well, I would just follow that up with, I definitely, I represent, a lot of the places I represent are extremely rural, right? You show up in one of those neighborhoods or on the street with a car with tinted out windows and you park there, right? You're going to get stopped. There is no doubt, and it is not going to be by the police, right? I can just guarantee that, right? That is 100% going to happen.
Sure.
So that's what I'm trying to figure out, what you're trying to accomplish. Because that ain't going to work. It's going to have the absolute adverse effect.
Sure.
Right? I mean, they're going to be like, huh, that broke down. You could be in there, whatever. The tractor with a chain going to come get you.
If I may. And I have to tell clients that when they hire me. Like, let's say a client hires me for working in the Parkton zone. I have to say, well, and what I'll do is I'll have them look, we'll do Google Maps together. And I'll say, well, I'm looking, this is a 2-lane road, they have private driveways. I can probably sit about a half mile from their house because there's a pull-off here, and I can see what I can do from there. And I just truthfully tell them and manage their expectations on what we can do and what we can't do. That's the nature of the beast. Now, that said, the bulk of my work, there's a reason why I'm near Baltimore, because that's where the attorneys are, and where the attorneys are, that's where the work is. And the law of averages states that if the bulk of the population's in one place, the bulk of my work's going to be in that place. So while I don't think that this law will solve every issue or every hurdle, and quite frankly, it's not your job to make my job easier, it would definitely simplify my job. I do believe it would reduce police calls. And I do believe I don't know if there is an answer that fixes everything. I wish there was. And I'm sure that compared to some of the issues that you guys deal with every day, this may seem like it's not as important. But it's important to my livelihood. And if it prevents the police one time from talking to me while there is some crime going on that they need to be protecting somebody else, I think it's a pretty safe bet. Thank you.
Thank you.
Thank you, Senator Bailey. Thank you to this panel. Looking around for any further questions. Seeing no further questions, that concludes the hearing on Senate Bill 701. Thank you, Senator Klausmeyer. Really appreciate your joining us. You too. We'll now move on to Senator Jennings, who is with us with Senate Bill 837. Senator Jennings.
I'm sorry, I'm just writing down his name so I can. Thank you very much, sir. Really appreciate it. Thanks for your time.
Thank you, Mr. Chairman. For the record, Senator J.B. Jennings for Senate Bill 837. This bill deals with vehicle registration fee. It's a pretty simple bill, and I'll lay it out. Car registration fees are done on the standard cars are a 2-year fee. When you return your plates in, you're only entitled on a 1-year basis, meaning, and I'll give you an example. You buy a car, let's say you have a car, it's registered on January 1st. So January 1st of 2022, you pay the registration fee for your car. You decide December 30th that you're going to sell the car or do something else with it, and you turn in your tags. Because you did that within 12 months, and there's still more than 12 months left on the registration fee, MVA will refund you 50% of your registration fee. If you do that on January 1st, even though you've got 364 days till the tags expire, you won't get anything from the MVA. What this does is it's just like your car insurance, because when you turn in your tags and you cancel your car insurance, they will refund your money, the insurance company, at a prorated schedule. This does it on a 1/12 schedule. So if you turn your tags in on January 1st, the example I gave you, you will get, 12/24 of your money back. It's pretty simple. I think it's fair to our constituency. I've had several people over the years who've contacted me on it, complaining because they've sold a car or turned the tags in, and they're out half their money because they did it too late. And it's just, again, 1/12 of the year is how it's broken down in this bill. If you look at the fiscal note, I think it's pretty high. I don't think there's that many cars that are turned in. $17 million is what they're saying it's going to cost us. MVA has not gotten back to me. I have not heard anything from them on this. I just think that that's a pretty high number for car registration fee at $130.
Questions for the sponsor? Thank you, Senator, for joining us. We appreciate it.
No problem.
Thank you for bringing us this bill. That concludes the hearing on Senate Bill 837. We'll now move to Senator Watson with a towing bill, Senate Bill 731. Senator Watson.
Thank you, Mr. Chair and colleagues. Thank you for the opportunity to present this legislation for you today. Senate Bill 731 provides for the electronic notification of secured parties or lien holders with vehicle information that's required in statute when a vehicle is towed from a parking lot. The towing company would only be able to contact the secured party electronically if that form of notification is agreed to by the tower and the secured party in writing or by electronic communications. Most transactions these days can be handled electronically, including purchasing a home, securing a loan, etc. This bill makes sense and brings towing into the 21st century and being able to leverage technology. Under current law, when a vehicle is towed from a parking lot, the towing company is required to notify the owner, any secured party, and the insurer of record by first-class certified mail, return receipt requested within 7 days. Providing for electronic notification of secured parties will save towing companies money and will allow for the resolution of matters more quickly should a vehicle owner not contact the tower to reclaim the vehicle. The legislation has been discussed with the Maryland Bankers Association. They approve of the language in the bill, have no concerns. They are members of the Towing Recovery Professionals of Maryland here with me, testifying in support of the bill, who can respond to more specific questions. For these reasons, I ask the committee respectfully to give Senate Bill 731 a favorable report. Thank you.
Great. Thank you, Mr. Chairman, members of the committee. Andrea Mansfield, Manus Canning and Associates. I'm here on behalf of the Towing and Recovery Professionals of Maryland. I want to thank Senator Watson for sponsoring this bill. And actually, I think you did a great job covering all the main points. Hopefully this one's a little bit easier or a little more simple than the last towing bill you had before you last week. But with that, I guess I would just say thank you for hearing the bill. Yes, we have spoken with the bankers. They are in agreement with this language and have no concerns with the bill. And Mr. Parrish is here from the association to talk more specifically about the process and how that would work, or to respond to questions should you have any. But thank you. We urge a favorable report.
Good afternoon. Thank you, Charles Parrish, Legislative Chairman for Towing Recovery Professionals of Maryland, as well as the Legislative Chairman for the local municipality towers for Baltimore County. I've been towing for 30 years. I specialize in non-consensual towing. Senator Watson did a great job explaining what it is. I just want to give you an example. For the last 2 years, myself, along with towers throughout the country, not just in the state of Maryland, we've been testing this with over 250 financial institutions. On the second day, once a vehicle becomes abandoned, by law, we're required then to do an abandonment, which then starts the process to do a CS-78, which is how we dispose of a vehicle to an ADR. Towers are not allowed to sell the vehicles. They must transfer it to an ADR. So the first step in that is notification. We're starting with the banks, the finance, because it's a lot easier, because registered owner would be through MVA, insurance companies is also through MVA. But with the bank financing, what we did, so on the second day, I did an email notification to the bank once we found out who the lien holder was, if it had a lien holder. By the third day, the next day, or the day after, I was getting a call from them, and they were picking it up before the 7th day. Same scenario, I still, as required by law, are required to do it by certified mail. So at the second day, I was then sending that letter out. It would at the least be 21 days. During the pandemic, of course, it took months, some even up to 9 months. But on the normal, it was from 21 days to 3 months. Storage fees throughout Maryland range between $15 to $85 a day. Finance companies were loving it because we were saving them money. And towers, most of us are small business owners, which have small lots. It was freeing up our space so we wouldn't have cars piled on top of each other. Thank you very much. I hope you give strong consideration to this. It is with the times, and I think it's time we do that. Thank you, and thank you, Senator Watson. Thank you, committee.
You don't sit down. Don't sit down.
Okay. Yes, sir.
And look, I don't have any problem in principle with the bill. First of all, what's an ADR?
Automotive dismantler recycler.
That's who you send it to.
Junk
Just get
yard.
rid. That's a junk. You're junking it because nobody
Sure.
ever got it. Okay.
Yeah.
Next is, so under the current system, you would pull up the registration, and the registration would say there's a lien, and the lien's by ABC lien holder, right?
Yes,
And then you
sir.
send them a certified mail, and everybody's protected because You got the registration, says their name, you can look up their address, you send them a certified mail, you tell them, I got your car, come get it. I got it. So, and so everybody's protected, because you can show, it's on the registration, it says the lien holder. I notified that lien holder, here's a certified letter, and we got it. How do we protect it in this case? Because is the registration say, here's lien holder's email address? I just trying to understand how we protect that chain, because the chain's pretty solid right now. It's in writing, you got your letter, you show them you got it, you junk their car because they never came to get it up. I just want to make sure the lien holder actually gets notice. How's that work?
The way it works right now, the way we've been sampling.
You guys are doing
is-
it, yeah.
Right.
Or
is
under the bill.
On the email notification, they would have to use ABC Bank. Now, the pay-as-you-go, that's going to be where it's going to be hard, but unless we have permission from that finance company to do so in an email writing or a letter saying that we're allowed to, they're going to give us that email that we're to use as a contact. So the tow company, as myself, let's say, it would come from my email to them. I would then get a response back from them saying, received, we want the vehicle, how much, typical. How much is it? What is your hours of operation? Bada bing, bada boom.
But how did you get their email?
I contact them.
You just, because you got the address, you call them and you.
I got the
figure out
company,
okay.
the bank name.
Okay, now, so you got an email. Now, if you don't get an email back, they don't respond, because sometimes email addresses change. When I'm watching lenders, I just had a case with a bunch of lenders in it. It was the darndest thing, because they kept selling and selling and selling, and I kept chasing to figure out who the lenders were on stuff. I had like 25 lenders in this case. It was horrible. But if you don't get an email back, are you just go ahead and junk the car, or then what happens?
No, if we don't get the email verification back that it's okay to notify them by email,
Right.
I then have to go through the
You
certified
gotta go to
letter.
certified mail. Okay, so the email has to be agreed upon. So you send them, you look them up, you send them an email, they send you back, got it, got your email, we'll be there to get it, or we don't want it, it's only got $1 left on the lien, we're not coming for it. And so you gotta change, but if you can't get that, then you gotta go by certified.
Correct.
Gotcha, okay.
And just so you know, most of these banking, it's under their loss and recovery division. Same as their mailing address, they also now all have email addresses.
Gotcha. Thank you.
Right, and I guess just written really quickly, that's why also the bill is specific, and that's what the bankers agreed to the language, that it must be in agreement with the secured party. That way, we would have that information, the
Yeah,
towing
you'd have a
company
record.
would reach out.
Yeah, I just want to be able to establish a record, so somebody, if the car gets junked, and they can say, I gave you notice, you agreed to this, but if you didn't get notice, if you don't have the email back, you gotta do the certified. I'm good, thank you.
Okay, thank you.
All right, so no further questions. Thank you all very much. Thank you.
Thank you.
Thank you.
Thank you, Senator Watson. All right, with that, that'll conclude the testimony in the hearing for Senate Bill 731. We'll now move on to Senator, or Vice Chair Wallstreicher with Senate Bill 875.
Thank you, Mr. Chairman. Members of the committee, I'm honored to introduce Senate Bill 875. Over the years, the General Assembly, and this committee in particular, has done an amazing job of expanding our fair housing laws. The chairman most recently passed source of income as a protected class. Ours is a history of growing inclusiveness and expanded fairness. But there is one class of Marylanders who surprisingly go unprotected in current law, our immigrant neighbors. Immigrants, many of whom speak limited English, are uniquely vulnerable. They deserve our attention and the unambiguous protection of our laws. Senate Bill 875 does just that. I want to thank MMHA and CASA for coming together and supporting this important bill. That doesn't always happen. CASA, of course, is a wonderful organization representing primarily Central American refugees, many of whom live in my legislative district. Those immigrants deserve these protections. But just to be clear, this bill protects all immigrants. This generous nation has recently accepted thousands of Afghan refugees who assisted our service members. They are covered under this bill. At some point, we may be required to absorb thousands of Ukrainian refugees, which I would welcome. They too are protected under this bill. Immigrants are our neighbors. They live in our communities. Discrimination on the basis of immigration status is wrong, and it's deeply harmful when it comes to housing. I hope we can once more stand up for our immigrant neighbors. I ask for a favorable report.
Excellent, thank you very much, Mr. Vice Chair. Mr. Wiggins, go ahead.
Thank you, Mr. Chairman, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. I want to thank the sponsor of the bill for bringing it. I think this is an important bill for both, I'll say this, both work and personal reasons, I'll put it that way. And so, you know, I want to thank him and commend him for working with us. He reached out to us early, engaged us on the issue. We do have one amendment that I understand is a friendly amendment. And so again, you know, I can't say enough about the work that the sponsor does, and want to thank him again for just working with us on a consistent basis. Thank you. Happy to take any questions.
All right, questions from the committee. Senator Sidnor.
Thank you. A question, in trying to distinguish between immigration status and maybe national origin, what's the distinction?
So if I discriminate against you because you are from El Salvador, then that is currently not legal. But if I discriminate against you because you are a green card holder as opposed to a citizen, then that is currently legal under
Yeah, that's what we're getting
law.
at. Okay. Thank you. So,
Yep.
thank you.
And just to be clear, some federal benefits, namely Section 8, make that distinction. This bill would not change that. In other words, if federal law requires a distinction, this bill doesn't obviate that. But in most circumstances, it makes that distinction illegal.
All right, seeing no further questions from the committee, that'll complete the testimony and the hearing for Senate Bill 875. Thank you very much, Mr. Vice Chair and Mr. Wiggins. We'll now move on to Senate Bill 653. Senator Wallstreicher.
Thank you, Mr. Chairman. Quick change of subject matter. And I would love to invite my panel up to join me if that's okay with you, Mr. Chairman. Excuse me. Thank you again, Mr. Chairman, members of the committee. This bill requires ignition interlocks for all DUI offenders. As you recall, this is designed to close a loophole left after the passage of Noah's Law, named after our hero, Noah Liada. This bill isn't new, but let me re-up the critical urgency of this legislation. The pandemic era will go down as among the most dangerous period in the history of our roads. The last 2 years have been traumatic. I can't explain to you why that's been the case. At first, I thought it might be simply because traffic was lighter, but that's obviously no longer the case. I just don't know. But here's what I do know. More people are driving drunk, and more people are dying because of it. This is an unacceptable policy outcome. Families are being destroyed, and it's now time for us to act. We have options. We can close down bars and restaurants. We can dramatically increase criminal penalties. Or we can take a non-punitive approach that we know works. Ignition interlocks work. They are discreet and they work. They let people get to their jobs and they work. They let people get to school and they work. They save lives because they work. We can't keep going on like this. If the future is like the last 2 years, we become truly dystopian. Let me conclude with a quick gut check on intellectual consistency. If you believe that PBJs are convictions, then this bill is intellectually consistent. Convictions come with consequences, and interlocks are an appropriate consequence of a DUI conviction. If you believe that PBJs are not convictions, which is what I believe, then this bill is also intellectually consistent. The whole idea of probation before judgment is that the defendant takes some mitigating action as evidence to the judge that a conviction should not be entered. Interlocks are an appropriate mitigating action. I hope and pray that we can get this done this year. Our constituents support it, and lives depend on it. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. My name is Kurt Erickson, and I serve as president of the Maryland nonprofit Washington Regional Alcohol Program. You have our written testimony, so let me just highlight 4 succinct aspects of Senate Bill 653, which we support, and which seeks to expand the universe of persons subject to Maryland's Ignition Interlock Program to include persons put on probation for either driving under the influence of alcohol or driving while impaired by alcohol. Number one, according to MVA, 40% of persons adjudicated for either DUI or DWI in Maryland in 2019 were granted probation in the form of probation before judgment and therefore not subject to the full universe of public protections, namely participation in Maryland's proven effective interlock program. 2, the National Highway Traffic Safety Administration shows that, quote, interlocks typically are used as a condition of probation for DWI offenders to prevent them from driving while impaired by alcohol after their driver's license have been reinstated, close quote. The need for such in Maryland is all too clear, as fiscal year 2020 MVA data shows that more than 6,300 drivers were prevented from driving after consuming alcohol last year as part of the interlock program. 3, in a state where nearly a third of traffic fatalities still involve drunk drivers, not using Maryland's existing and offender-paid interlock program for the full universe of DUI and DWI offenders in the state is at best not using every tool in Maryland's toolbox to prevent drunk driving. At worst, it's potentially deadly, as 2020 also bore witness to Maryland posting a nearly 10% increase in the number of alcohol-impaired traffic fatalities last year. 4, and finally, and in summary, Senate Bill 653 looks to simply ensure public safety along that route used by nearly half of persons arrested for drunk driving in Maryland by subjecting all 21 902A and B offenders to Maryland's interlock program as a condition of probation. I thank you in advance for your consideration of favorably reporting this potentially life-saving legislation. Thank you.
Mr. Chairman, committee, thank you for having me. My name is Chris Swanger. I am the president and CEO of the Distilled Spirits Council of the United States and the Foundation for Advancing Alcohol Responsibly, a national not-for-profit organization dedicated to eliminating drunk driving and underage drinking. A first-time arrest for DUI doesn't mean it's the first time someone has driven drunk. It's just usually the first time they've been caught. The Centers for Disease Control and Prevention estimates that DUI offenders drive drunk almost 80 times before receiving their first arrest. Most first-time DUI offenders meet the criteria for substance abuse or dependence. Until and unless these issues are addressed, they pose a public safety threat on the roadways. Ignition interlocks are the most effective countermeasure to stop drunk driving and are affordable. Ignition interlocks does a favor for the offenders and keeps them safe and those on our roads safe. Ignition interlocks should be mandatory for every drunk driver, including those who receive probation before judgment. Please support SB 653 because it makes it impossible for the DUI offender to drive drunk again and hurt an innocent person or hurt themselves. So please, I implore the committee to please try to get this thing done on behalf of Rich Leota and Noah and victims all over the great state of Maryland. Thank you.
I'm Rich Leota, the father of Officer Noah Leota. I've been here many times before. The bill that we're talking about right now is basically we're trying to help people change their bad behavior and save lives, save their lives and save the lives in the community. And Noah would tell me, he said, Dad, I'm not catching people that are bad people. I'm just catching them at their lowest moment, and they can change. He would want this bill to be passed because this is just giving them a chance to change, giving them that opportunity that when you have a PBJ, what I'm finding is many times, 60% of the times, judges are not requiring the interlock. That's leaving a gap there where these people are not given that full opportunity to change, because 67% of the time, when people are given an interlock, they don't repeat. That's a big number, and 15%, it reduces that of fatalities. Look, what we're trying to do here is make a difference. And we can do that very simply. I mean, the person that struck and killed Noah, you know what he told me? He said at his parole conference that he was in jail because of leniency, because of each time that he was caught, he was a catch and release, and there were no consequences for his actions. All I'm saying here is that as a condition of the leniency of a PBJ, and that the judge install an interlock as a condition of that leniency. That's all we're asking for. We want that to make a difference and save lives. That's it, bottom line, saving lives. Can't change it for Noah, but maybe we can do for others. Thank you, and I hope you support this bill.
Good afternoon. Lieutenant Adam Curry with Montgomery County Police Department, the Deputy Director of the Traffic Operations Division, the agency Noah worked for. Montgomery County Police Department supports Senate Bill 653. This legislation further strengthens current Maryland ignition interlock laws so as to effectuate the use of these devices for individuals granted probation before judgment when charged with an alcohol-impaired driving offense. According to the Centers for Disease Control Prevention, ignition interlocks, quote, have demonstrated their effectiveness in controlling impaired driving while they are installed, end quote. In 2020, 14,710 people were arrested for driving under the influence of alcohol or drugs in Maryland. Nearly 6,000 of those arrested in 2020 for DUI were granted PBJs. As a result, approximately 41% of those arrested were not required to place ignition interlocks on their vehicles. While 2/3 of those arrested for driving under the influence do not reoffend, the additional 1/3 become subsequent offenders. While not requiring installation of ignition interlock for all those who receive probation before judgment for an impaired driving offense, Maryland is missing an opportunity for early intervention with a substantial number of individuals who are highly likely to reoffend. Senate Bill 653 is a bill that will have immediate life-saving measures. It will assist in preventing those most likely to reoffend to not do so. It will allow for some type of immediate consequence for all of those who drive impaired. It will better establish the judicial system's intolerance for a crime that can result in death, as well as put forth the sanction that the Motor Vehicle Administration can effectively enforce through real-time data. This legislation will not only act to hold violators accountable, but act as a promise to sober drivers that all persons have a right to safe roadways. By supporting Senate Bill 653 and listing this as an important matter, Montgomery County acknowledges the benefits of expanding the current ignition interlock laws within Maryland. This bill makes Noah's law stronger and more effective. Montgomery County urges the committee to adopt a favorable report on Senate Bill 653 and thank Senator Wallstreicher for sponsoring this important matter. Thank you for your time.
Thank you very much, Lieutenant. All right, we have a couple questions. Senator West.
Thank you, Mr. Chair. So for the second time this afternoon, I'm a little confused by the drafting. I'm looking on page 2 of the bill, and it talks about how it's applied for driving while impaired by a drug, a combination of drugs, or a combination of one or more drugs and alcohol. Now, my understanding of interlocks has been that they're like breathalyzer tests, and they determine how much alcohol is in the person. I wasn't aware that they apply in the case of drugs. So why can someone explain why this bill is drafted to include drugs?
Well, I can tell you my experience, because I've done court monitoring, if you've read my testimony. And actually, I saw it in a case where somebody did blow a 0-0 on the breathalyzer. And the judge still insisted that the person get an interlock. And the reason the judge did that, and his words from the judge were from the bench, he knows that when you're using other drugs, alcohol is usually engaged in that same type and manner. The people are going to be, because alcohol is just a drug also. So therefore, he made sure that even though that person blew a 0-0, he insisted on an interlock and made sure that that was part of that person's condition.
Okay. Senator?
Yeah, so I agree with Mr. Liotta about the idea here, but nonetheless, should we need to tighten it? I'm absolutely open, and I think the advocates are open to the idea here.
Okay, great. And somebody, answer me another question. My understanding is that the interlocks had been improved so that you couldn't have somebody sitting beside you who would blow, who has consumed no alcohol and would blow into it and therefore pass the test so you could drive the car. Is that correct?
Yeah, so I think we passed a bill, in fact, that resulted in that very outcome, and most of us were here. I think it requires like a little photograph taken up at the person who is blowing
Right,
to ensure
okay.
that that's the same person.
Good, okay.
Yep.
I thought we'd done that, but there's nothing about it in here, and so I just wanted to confirm. Thanks.
Yeah, and, as I noted, to be honest, part of the reason this got left out years ago is because there was the idea that these very large devices provided some type of stigma. If you looked into, mom's minivan and saw that this big device, that would be somehow embarrassing to her or her family. Since we passed the original law, not only has there been advances like you noticed about the camera, but they have become much smaller and much more discreet. None of this technology was ever designed to embarrass anyone. It's designed to save lives. And so as they have become much more tiny, as have everything else in our lives, computers, cell phones, everything else, the embarrassment factor that seemed to play a role 7, 8 years ago when the original bill started to percolate, some members of the House Judiciary Committee were especially focused on that embarrassment factor. These devices now are very, very discreet.
Great. No one is second to me in my support of using modern developing technology to solve problems. Thanks.
Just a quick question. Is this bill in any way different from the bill that was introduced last year?
This bill is not different than the bill that was introduced last year, to my knowledge.
Thank you.
Thank you, Mr. Chairman. When we talk about recidivism, what is the difference in the difference if they had a first conviction was a PBJ or the first time was a conviction?
It sounds like we'll get you that information after the hearing.
Okay, I would like, because, it's usually extenuating circumstances. At least we've been so educated, and judges have been so educated when we have a PBJ, right? And I heard you use the term recidivism. This would stop it because people are more likely to, recommit the violation even once they were convicted. But I don't know what that data is for probation before judgment.
Yep, I think that data is accessible, and we will definitely get it to you. That's a good question.
Thank you.
All right, seeing no further questions, thank you all very much. Thank you. We'll now move on to the next panel. Mr. Daggett, I saw him here. Mr. Daggett, okay. We have Robin Stimson, Roderick Howard, Ms. Giannetti. I'm sorry, yeah.
All right, my name is Roderick Howard. I am the Regional Executive Director for Mothers Against Drunk Driving, specifically for the Mid-Atlantic region, which includes Maryland. And I am here to ask all of you committee members to please pass this bill that will, again, close the loophole for Noah's Law. If you sit and think about it, this is a life-saving small step that will put us in the right direction to get to 0 victims of drunk driving. My colleagues here are working tirelessly with a lot of victims, and until we get to 0, the increase of drunk driving is just going to increase, and we're going to see more deaths on the road. So I'm asking each committee member to please pass this law and closing the loophole for Noah's Law.
Thank you very much, Mr. Chairman. On behalf of Mothers Against Drunk Driving, we want to also thank Senator Waldstreicher for your leadership on this bill. I am Robin Stimson. I'm the manager of Victim Services. And, when I first speak to a victim or a family for the first time, I usually tell them, I'm so glad you had the courage to reach out to us at MAD. but I wish I didn't have to connect with you in this way. I'm left saddened and angered over the reality that I never got to meet Noah, Alyssa Joy Withers, Darius Brown, and the countless other victims who have been killed or injured due to a substance-impaired driving crash. By the time victims such as Rich Liotta and his family find support through MAD, the crushing reality that their loss or injury didn't have to happen is almost too much for them to bear. The grief is all-encompassing, and the effects of the loss are long-lasting. We should all know Mr. Liotta for who he is, not because of who or what he has lost. Drunk driving is 100% preventable. During this hearing, my colleagues and I were prepared to share pertinent data that highlight the importance of the bill. We can discuss industry findings and national trends. We can even review details of the program, but what we cannot do is bring a survivor's loved one back or make them uninjured. Nothing will negate the fact that in 2022, there is no excuse or reason for anyone to drive while drunk. Ignition interlock is a vital, life-saving tool that ensures offenders remain functional and contributing members of society. It offers minimal disruption to the driver and allows them to continue to provide for their families and maintain busy schedules. As a result, the ignition interlock device not only presents a benefit to the offender, but it's important to the overall health and safety for the community at large. Mr. Chairman and members of the committee, please pass Senate Bill 653 and give your constituents and victims a future of no more victims and drunk drivers a true second chance. Thank you very much.
All right, questions from the committee? All right, seeing none, thank you very much. All right, I'll call him one more time. David Daggett. All right. Mr. Giannetti.
Opposition?
Yep, we'll now switch to the opposition panel. There you go.
Thank you very much. Members of the committee, John Giannetti for the Maryland Criminal Defense Attorneys Association. First of all, let me say thank you, Mr. Chairman. I appreciate what you're trying to do with this bill. And you can see we changed our position on this bill compared to what we took in the House, because this time we're putting in opposed with amendment. And, you know, I only have a short amount of time. I'll certainly be willing to go more into detail. Any of you who know me as a senator knew I put the interlock bills in when I was senator. I put the bills in. I think it's a device that really works well. The most important document you can look at is the document that I filed here from Lenny Stam. Lenny Stam is a member of our association. He wrote the book, literally wrote the book on Maryland drunk driving. If you practice this law, you look at that, you look at Lenny Stam's book, you're using it. The judge has it, the prosecutor has it, the lawyers have it, the defense attorneys. Why is that important? Because the philosophy in general of the Maryland Criminal Defense Attorneys Association would be against this bill, in general, because the association says anything that takes discretion away from our judges, we're not in favor of, because we, as defense attorneys, want to be able to show the judge how our client has a unique circumstance and maybe deserves either a lighter sentence or a different way of handling the sentence. So in general, we don't like mandatory penalties. This is a mandatory penalty, so we're against it for that. However, I felt, based on the hearing in the House and what I see here, this is maybe the year for this bill. And if you want to pass this bill, you got to do it exactly right. Right now, the way that this bill is written, not only with the 21902C issue about why would you put an interlock on a person who has a drug problem, why would you put the interlock there? The second thing is, anyone who is a truck driver, who has a CDL, who gets a PBJ on a 21902B, deservedly, will now not be able to work because they'll have a interlock restriction on their license. We don't want all the truck drivers to lose their jobs. Also, this bill does not address the issue of an out-of-state driver. I'll leave it there, but I can answer any questions. There's many problems with the bill if you're going to pass it.
So your amendment is what?
Well, here's the thing. If you have to do there's about 7 different points that Mr. Stam made that makes this bill unworkable. I mean, as far as, you know, we're the ones, okay, myself, practiced law 25 years, worked in Valerio. Sometime in Valerio's firm, I'd have 5 of these cases a week, drunk driving cases. I probably did over 500 of them. I've taken the jury trial. Every case is different, and that's the problem. You're trying to put a philosophy. So what I suggested as an amendment, and it's at the bottom of my submission, is if you just allow, give back the judge a little bit of discretion and allow the judge to not put on the interlock if that judge finds an extreme hardship would be created to the defendant. And what that extreme hardship exception would allow is this. It would allow a person that would lose their job, that's an extreme hardship. So if he's a trucker, all right, and now all of a sudden he has to have an interlock, well, you could find, if I'm going to lose my job, judge, please find an extreme hardship, don't put on the interlock, don't put on that restriction. Number two, let's say I'm a person in West Virginia, I come into work in Maryland, now I have to get in the interlock program, and guess what? A West Virginian can't join the Maryland interlock program. But now I've got a law that says I can't get my privilege to drive back in Maryland until I finish the program. So I don't ever get my privilege back. You could convince a judge that's an extreme hardship. And maybe the judge would say, okay, that's fine, I'll put that exception for you. So you have to come up with something to address some of the points about why in the trenches this bill doesn't really work. So that's what the suggestion was.
Thank you.
All right, seeing no further questions, thank you very much.
Hey, thank you very much. Good to see you, Mr. Chairman.
Actually, I'm sorry, Senator Walsh has a question.
Thank you. I just wanted to say on the record, I'd have to talk to the advocates, but I think we are open to a conversation about an extreme hardship.
And you know what, and in the attempt to try to get, and realize that I tried to get 11 different lawyers I made contact with by email to try to be present here. Because I didn't really, quite frankly, didn't want to come and testify against an interlock bill. But here's the thing, all the lawyers are in court right now, because they're all defending the drunk drivers and trying, whatever, they're doing their job. But the thing is, we can get you Lenny Stam. Lenny Stam is very responsive. Lenny Shapiro probably is the second highest in that they're willing to work to try to make this work for you because we feel the bill is likely, it has some momentum to it, and we want to make sure it works at the court level. So I thank you very much for that position, Mr. Vice Chair. And just work through me, and we'll get them to you. All right. Thank you all very much.
All right, thank you very much. Good to see you.
Good to see you.
All right. And with that, that will conclude the testimony for Senate Bill 653. We'll now move on to Senator Lee with Senate Bill 769.
Mr. Chairman, can I get my panelists up here? There is one panelist that could not attend. Her name is, and I think Sandy knows, Sarah Curzon, who testified on the House side but could not attend the hearing today, but she submitted for the record a recording of herself on her testimony. Okay. Everybody here? Yeah. Hey, guys. Okay, SB 769 is a reasonable and thoughtful way to apply justice in circumstances where the law provides punishments that do not fit the crimes when child victims of sex crimes commit serious offenses against their abusers. There is a limit of 1 year from the time of the abuse, so this is not a green light to hurt your abuser, rather. It provides no protection from adult prosecution. What it does allow for is the mitigating factors of abuse, the youth suffer, to be considered for sentencing and to have appropriate standards apply in the sentencing process. As you know, adverse childhood experiences, which are referred to as ACEs, or more than a catchphrase when it comes to juvenile justice system, especially concerning victims of sex crimes. And studies have shown approximately 90% of children in the juvenile justice system have experienced at least 2 ACE, that is adverse childhood experiences, and about 48% have experienced 4 or more. The population we are discussing under this bill, specifically youth victims of sex crimes, is self-evidently above the high end of these broader studies. Consider nationally that 73% of all juvenile justice involved girls have histories of physical and sexual abuse. In combination with traumatic bonding and post-traumatic stress disorder, children with undeveloped brains cannot control their emotions and impulses and cannot evaluate the risks the same as adults do. These mitigating factors must be considered at sentencing for these specific children for these specific crimes against their abuser. And this bill is not a safe harbor bill, such as the one you'll hear next week for nonviolent crimes. But this bill does cover similar population of child victims and sex crimes. Our state does not have a real duress defense for coercive circumstances. So short of a complete defense, this bill is just asking for a more reasonable application of sentencing for youth victims of sex crimes, only for crimes against those who abused them within 1 year of that abuse, which has to be proven by clear and convincing evidence. And of course, you'll hear from the victims of abuse who later were victims of the criminal justice system. They can tell you their stories best. But the common denominator is the law is not flexible enough to allow judges and prosecutors to dispense justice, and not just the brutal force of inflexible laws. The intent of this legislation and the actual language contained in this bill allowed sentencing judge to consider the mitigating factors of child victims of sex crimes when they commit a crime against their abuser. We can resolve real and perceived technicalities for these kids and for justice generally. The opposition leader points to technical concerns that our amendment confronts. We have an amendment. You might look at the amendment when you get it. Brings up examples outside the scope of the bill or calls this process duplicative. This legislation is needed and has technical soundness as well as narrowness to apply only to individuals that must be so hard to find that no relevant examples can be summoned to oppose this bill. For these reasons, we request a favorable vote on SB 769 with the technical and clarification amendments to confront the concerns of the judiciary that are relevant to this bill. I'll turn it over to my panelists. Would you like to speak first?
Sure.
Thank you, Mr. Chairman.
Thank you so much, Mr. Chairman. James Dold, for the record, representing Human Rights for Kids. We just want to start at the outset thanking Senator Lee for her leadership in introducing this bill. I come before you both as the CEO and founder of Human Rights for Kids, as well as a survivor of child sexual abuse and child labor trafficking that I experienced as a child. One of the reasons that really animated my life's work to work on behalf of the most vulnerable children in our communities. There's two really important critical points of this bill that I want to spend time speaking about. The first is the first section. And what this section does is it just requires that when judges are sentencing children who've been transferred and prosecuted and convicted in adult court to consider specific mitigating factors of youth, including their age, their trauma history, what their home and community environment were like, their intellectual capacity. These are all critical components to make sure that whenever a judge is imposing whatever sentence they're going to impose on a child, that they have a full scope and understanding of who that child is before them. This is particularly relevant for kids who have very high adverse childhood experience scores. I will also just note that this same exact language was actually adopted more than 8 years ago by the conservative state of West Virginia. The second part of this bill deals with the protections that Senator Lee specified, which are for child sex crime victims. The case that really animated this legislation was that of Sarah Cruzan. Sarah was an 11-year-old girl who was walking home from school who was preyed upon by a sex trafficker. From the age of 11 to 13, she was raped by this man. Then from 13 to 16, he forced her into prostitution. She ran away for a week, she returned, and she killed him. And the entire weight of the criminal legal system came down on her. She received a life without parole sentence, plus she had to pay $10,000 in restitution. We see cases like this all over the country, cases of Centoya Brown, Alexis Martin, Jared Harper, Patrice Smith in New York. It should not take an act of the governor to intervene in cases like this, and what I would submit is that if this was your child, if this was your son or daughter who had been sexually abused, raped or trafficked, and they killed the person who did that to them, what should we do in those cases? Our answer to that question says a lot more about us than it does about that child. And what this bill does is simply give the judge the ability to send that case back down to juvenile court for proper disposition. Child sex trafficking victims and child sex crime victims are the victims in these cases. And we need to give judges more flexibility in these very unique circumstances. And for that, we would urge this committee's favorable report. Thank you.
Thank you. Has everyone had the opportunity, please?
Good afternoon, Mr. Vice Chair and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent both youth and youth charged as adults in the criminal court system. What brain science has told us is that children are different. And that is especially true for children who have experienced trauma. And in fact, most children within the juvenile justice system have experienced what Senator Lee was referring to, adverse childhood experiences. As a result of that trauma, children react differently to situations that may not be perceived as a threat to your average child, let alone your average adult. But the problem is that our criminal justice system here in Maryland treats those children as if they were adults. Our criminal justice system ignores the trauma and the experiences that these children have been through and doesn't give them the option of being treated like children. Transfer to juvenile court is currently unavailable for a 16 or 17-year-old charged with murder. And so if you have a 16 or 17-year-old who has been a victim of trafficking, who has been beaten, who has been broken by an abusive adult, and finally reacts and strikes back against the person who has stricken them repeatedly, that 16 or 17-year-old child is incarcerated with adults, punished as if they were an adult, without consideration for what they've been through, without the option of getting the treatment and rehabilitation that they need. And if these children could only get the help that they're asking for, they could be rehabilitated. The underlying trauma could be addressed, and they'd have a chance for a life ahead. Instead of the continued sexual abuse, the rape, and the suicide-inducing conditions of the adult prison system, especially to vulnerable youth. I've provided quite a few statistics in my written testimony, but what I would ask this committee to do is when we see a 16 or 17-year-old who is crying out for help, we shouldn't discard them, and instead we should offer them assistance. And for these reasons, I urge the committee to issue a favorable report on SB 769.
Good afternoon, Vice Chair, Chair, members of the committee. Elizabeth Hilliard with the Office of the Public Defender. I am standing in for Kimber Watts. You have her written testimony in which she extensively discussed three things I will touch on today. First, as McCall and James both pointed out, children are different. You've heard about this extensively today. I know you've had juvenile justice bills in front of you all day. What we know and what the Supreme Court has consistently recognized for the past 20 years is that a child's brain is not fully developed. That means two things. First, often a teenager is more prone to making risky, unmeasured, and dangerous decisions. And at the same time, the part of their brain, the part of your and I's brain that would put a brake to that would calm us down and ask us to think about long-term effects, about the impact of our decision, is not yet developed. So when someone is, let's say, 12, 13, 14 years old, they are not the same person they will be at 25, 30, 35 years old. This bill simply encourages, requires, and ensures that a judge will consider such circumstances before imposing a sentence on a child. Second, children are extremely susceptible to peer pressure in a way that is perhaps unconceivable for those of us who have been removed from the, let's say, foibles of youth for the last 20 years. The Supreme Court has recognized, in fact, that even without peer pressure being exacted out loud, mere awareness that peers have been watching encourage children to engage in risky behavior. To illustrate how this plays out, we have a specific client story, and I think it's encapsulated in Kimber's testimony, so I won't regurgitate it here because I'm running out of time. But we urge this committee to report favorably on Senate Bill 769, and thank you for your consideration.
Thank you very much. I don't know if I should be asking this of the sponsor, but I was looking at the judiciary's written testimony and just had a couple of questions. On page 2, line 18, they mentioned something about the constitutionality of faith being included in this, and so I'm wondering why. That's the first question. The second question, and I'm not clear why, on lines 23 and 24 is saying that the court may not require that a comprehensive mental health evaluation be conducted. I'm just curious why you would want to take that tool away as well.
And if I may respond, Senator, so that's actually what the amendments that Senator Lee has offered do address. Those amendments address all of the concerns that were raised by the Maryland Judicial Conference. So that faith and will be taken out. That subsection 2 will be struck and replaced with finding on the record. So we tried to make sure that we took into consideration all of the concerns that were raised in their testimony. So they shouldn't. From my understanding, they shouldn't have any more issues, at least what was addressed in their letter of opposition.
Thank you.
You're welcome.
Thank you, Mr. Chair. So I'm looking at the second half of this. Well, the first half has this statement that the court may not require a mental health evaluation, but some of these standards that the court is required to consider, it seems to me would necessitate a mental health exam. The minor's ability to appreciate risks and understand the consequences of actions, the judge couldn't possibly determine that just by having the person sit in court. Excuse me? Oh, I'm sorry, you're taking that out?
Yeah, so the court can still order those mental health evaluations, and it can be considered under that factor. It's just that we struck that other subsection that said that the court can't order that.
Okay.
So, yeah.
All right, so that makes the bill consistent. So now I'm looking at the second part of that. So I'm looking at the literal language, which is the way I like to read bills. If the court determines by clear and convincing evidence that the individual against whom the minor is convicted of committing the offense previously committed a sex crime or human trafficking against the minor, and then certain things happen. So we sort of, in cases in which a husband enters the house and sees the wife in bed with another man and lashes out in a fit of passion, there's certain considerations given by the courts. But in this case, there's no requirement that it be a crime of passion. It's just if there was a sex crime or sex trafficking within a year, then if the defendant in the case kills the person who did it, first-degree murder, no passion involved, just comes and finds the guy within a year and kills him, then the defendant gets special consideration. I don't think we have anything like that in the law, do we?
Well, so I would say, Senator West, to respond. So this actual language, I will say that there's actually similar legislation pending at the federal level that the National District Attorneys Association supports that also factors into this. So that's one thing that I'll say as far as the standard goes. But it is about child sex crime victims who, again, the victim in the case, right, that they're being charged with are the people who committed that act of sexual violence.
No, I fully understand that. So somebody was foully abused.
Mm-hmm.
But what this almost does is give that person license within a year of the abuse to seek out the abuser and kill him.
So Senator James Dole, again, if I may respond, it's not about giving license or legalizing vigilantism. It's about recognizing that these children are victims of crime and that the court, in the court's estimation, they may say, look, I've considered all of these different factors, and I don't think the proper venue for this child is an adult court.
Well, okay, let's go to that then. That's the second half. Mm-hmm. So the presumption is that someone who sought out her abuser and killed him, the presumption is that that person, the minor, should be transferred to juvenile court. But In juvenile court, if you're convicted of a crime, when you no longer are a minor, when you turn, I think it's 21, you get out. And you're no longer incarcerated. So what this bill really seems to do is to authorize, I know it wasn't your intent, but the effect of the language seems to be to authorize someone who's been abused to kill the abuser and then go to juvenile court, and when she reaches the age of 21, she's free as a bird.
So I'm gonna let some of the public defenders come up and respond to that as well. But I will just say, from our perspective, these children are the victims in this case, right? And that we want to give the court as much flexibility as possible. And it may be the case that the judge, wants to impose an adult sentence. That may be appropriate. But if we're talking about a kid who's been sexually abused and raped over a period of years, and then they run away like Sarah did, for a week, and they return and kill their abuser, our position, we don't believe that those children should be getting adult sentences. We believe that the judge should have as much flexibility as possible, and that the system really should account for the fact that these are the true victims in the case. Not to excuse homicide or any other crime, but these are very unique circumstances.
This comes close to excusing homicide.
Well, it just opens up the opportunity for the court to have more options. That's the way that we look at it. And I'm going to let OPD respond as well.
Thank you, James, and thank you for your question, Senator. I appreciate it. I certainly also appreciate a very literal reading of the text, and I'll direct you to the provision that says page 3, line 4, at the end of the line, the court may transfer the minor to the juvenile court.
Yeah, but look at the next section. It says there's a presumption that the court should transfer the minor.
Yes, but it's still permissive. And in the circumstance which you're raising, which I think is very unique and few and far between, there would be absolutely no issue with the court rebutting that presumption. If you are creating a circumstance or a hypothetical in which someone, a 16-year-old who was the victim of sex trafficking or another sex offense under this title, was aware of the law and plotted an exacting revenge, which I would actually argue under their brain development would be likely impossible, the judge could make those decisions and rebut the presumption without having to follow the remainder of the sentencing provision. So the discretion in this bill is still retained by the judge. It merely reflects the import of victimization, and Michal is going to talk a little bit about battered child syndrome and battered spouse syndrome that would apply in circumstances such as these. This bill, although strongly favoring juvenile sentences for folks who have been victims of abuse like this, still allows the court to maintain full discretion.
Okay, thank you.
And Senator West, if I can just respond. So the scenario that you gave, a spouse walks in on their spouse cheating, in the act of cheating on them, and kills their spouse.
In a fit of passion.
Right. And that's exactly what that is. That's considered a crime of passion. And the way that the courts deal with that is that that's a mitigating factor, that it was a crime of passion. That's not what we're talking about here. What we're talking about is actually more in line with battered spouse syndrome, or in this situation, what it really is battered child syndrome. It's an individual who has been repeatedly traumatized by their abuser over a period of sometimes years, whether it's months, whether it's years. When we're talking about a child who has been repeatedly battered by this specific abuser.
Well, the bill doesn't use the word repeatedly.
Right. So
it's just a sex crime.
Yeah, but it's specifically somebody who has been trafficked.
Right.
And that's what that paragraph speaks to. So we're talking about somebody who's been repeatedly abused, repeatedly trafficked by this person. And it's not that they're plotting for a year to go and kill this person. It's that they're stuck in a situation where they perceive that situation as a threat, whether or not there is the normal legal definition of an imminent threat that you would need for self-defense. Because what happens is, because of the repeated abuse by this abuser, much like in a battered spouse syndrome, when you have a battered child, they perceive a threat where it might not be there. So because they've been repeatedly trafficked by this person coming over and calling them honey might be enough to trigger that. It's the perceived threats by the specific person who trafficked them that lead them to those actions. So it's not as much a crime of passion as it is a result of their trauma response to the situation, their trauma response to a triggering event by their abuser.
Okay. I hear your answer, and I'd appreciate it. There's nothing in this bill which seeks to differentiate a traumatic response, on the one hand, from someone who coldly plots to kill the person who has abused her within the year set up by the bill.
And I understand that concern, and that's what my colleague, Ms. Hilliard, was referring to, that these are things for the judge to consider. So it's because each person's pattern of abuse is not going to mirror the others, it's impossible to prescribe, here's how you fit into this pattern of abuse. But what this bill is asking judges to do is to consider that pattern of abuse, consider what this child has gone through, and make those considerations in deciding what does this child need. Does this child need services? Does this child, should this child's case remain in adult court?
Okay. Thank you very much for your answers.
Just real brief, somebody had said that the juvenile's sentence for an adult crime would be serving their sentence in an adult prison. That's not correct, is it?
So it's a 16 or 17-year-old child charged with murder would be serving that sentence in an adult prison. So it's a child charged as an adult.
So they would not serve it in the juvenile adult prison, or the juvenile prison. They would serve it with the adults. They'd be sending in
Once they turn 18, they are transferred to the Department of Corrections.
No. You
Oh.
said the child. Now they're not a child because now they're 18. But when they're 16 and 17, they're not serving it with the adult population, correct?
They're actually kept separate from the adults in the Department of Corrections in a facility in Baltimore.
Right.
And then the day that they turn 18, they're sent to the
And they
Department of
okay,
Corrections.
but they're no
So they're
longer a
not
child, then.
technically a child anymore, but they're
There you
serving a sentence for something that happened when they were a child. Their brains are still underdeveloped. That
then-
continues up until 25 for most
Gotcha.
youth.
And then, this is before imposing a sentence under this section, the court shall consider. I assume this is in addition to any aggravating factors, the nature of the crime and the like. This isn't intended to be exclusive of those. Is that right?
I'll allow my colleague to answer that question.
Just briefly, and thank you for the question, Senator Castley. Again, this is a bill that contemplates additional things to consider and for a court to articulate outside of what they already could articulate. I think it is really quite similar to contemplating the sentencing guidelines, right? A court
Well,
has to.
It's a really simple question. You weren't intended to exclude the aggravating factors. You're just saying, in addition to the nature of the crime and other aggravating factors, here's some mitigating factors you have to consider, right?
In addition to everything the court may already consider, we
Okay,
are asking them to
thank you.
consider these.
Just one real quick question. So if someone's charged as an adult, a youth charged as an adult, pending trial, where are they incarcerated? Where are they held? In a DJS facility, or are they held in adult prison?
So that depends on what their status is. So if you have a 16 or 17-year-old who is eligible for transfer, they are held there is a presumption that they should be held in a juvenile facility. However, 16 and 17-year-olds charged with murder are not eligible for transfer, and therefore they are held in the local detention centers. It varies from county to county how they're actually treated. I will say that some counties keep them separate, have a youthful unit where those children are offered education and kept separate from adults. In other counties, such as the one where I practice, those youth, 16 or 17-year-olds, are held with adults in the same cells as adults, without any education, without any services, without any separation from the adults. In fact, sometimes they're held in the same exact cell as somebody 2 or 3 times their age.
There's already a law on that.
I think there's a federal.
Yeah,
You're right.
I mean, I thought we had testimony on this, like, over the last 2 years, that to
It's-
put a child in a cell with an adult, they have to be, it can be in the same it could be in the Carroll County Detention Center, but they have to be in a separate area that's sight and sound excluded from the adult. So if they're doing that, I mean, that's a clear violation of existing law.
Yes, so there's 2 federal laws that apply in this area. It's the Prison Rape Elimination Act, and hopefully I'll remember what the acronym stands for, but JJDPA, Juvenile Justice Delinquency and Prevention Act. Both of those bills are federal legislation that is meant to protect children who are in adult custody, and that's the Prison Rape Elimination Act is where we get the sight and sound language. The Juvenile Justice Delinquency and Prevention Act, which Maryland is actually technically out of compliance right now, but I believe that there's pending legislation before this committee to fix that. Both of those would require these children to be held in juvenile facilities.
Well, they're
However,
not bills, those are laws, right?
those are laws, however,
They
Maryland right
wouldn't
now.
It's not they would require, they do require.
They do require it, however, Maryland is not currently in compliance with JJDPA. Maryland is currently out of compliance because 16 and 17-year-olds have no mechanism to be sent to a juvenile facility. And the Juvenile Justice Delinquency and Prevention Act, I know that there's a bill that was introduced by the Department of Juvenile Services, would fix that problem that we have right now, where Maryland is not in compliance with the federal law and risks losing federal funding. But to answer the earlier question, though, about the Prison Rape Elimination Act, it's the Department of Corrections is in compliance with that. It's the local jails, where it's a county-by-county policy about whether or not they're compliant with the Prison Rape Elimination Act. And some counties are fully compliant, some counties are less than compliant, and some counties have offered the opinion that it doesn't apply to them.
Excellent. Okay, thank you all very much. Did we hear from Sarah Cruz? That's the video, got it. All right, we'll now switch to the opposition panel, and we'll have Ryan Massey and Mr. Katzif.
Mr. Chairman, members of the committee, my name is William Katzif. I'm an assistant state's attorney from Anne Arundel County. I'm here on behalf of the Maryland States Attorneys Association in opposition to Senate Bill 769. Let me, first of all, point out the fact that really the procedures here do not really make a lot of sense. Let's suppose, for instance, someone is charged who is 14 or 15 charged with murder, or 16 or 17 and charged with some other type of offense that would give the initial jurisdiction to the adult court. Defense attorney most likely would file a motion to transfer to the juvenile court under Criminal Procedure Article 4-202. There's a 5-factor test, and the judge would the judge would hear the would consider the 5 factors. This would be an investigation by the Department of Juvenile Services. They would submit a report, and they might make a recommendation, and the judge would make a determination whether to transfer or whether to keep in the adult court. Okay? Or, on the other hand, there may be a person who is charged as a juvenile, and we believe that person should be waived to the adult court. Okay? When that happens, the court will order the Department of Juvenile Services to conduct a waiver investigation. They consider the same 5 factors. The only difference is where is who has the burden. Okay? If the defense attorney is challenging the jurisdiction of the adult court, it rests with the defendant or the respondent. If it's, in our case, we ask for upward transfer or waiver, the burden is on us. Those 5 factors are applied, and the court makes a decision. This would basically have the court redo what it has already done, considered the report of the Juvenile Service, or the Department of Juvenile Services, with regards to whether the case should be prosecuted in the adult court or in the juvenile court. This just simply has those additional factors when the court has already made a determination as to where the appropriate jurisdiction lies. It really doesn't make any sense. It adds things that really aren't necessary, duplicates the proceedings, and also, as pointed out before, there is a inference here, not just an inference, but there's a presumption that a case should be transferred to the juvenile courts when the court has already made a determination using the 5 factors test that it belongs in the adult court.
Remind us what, these are the Davis factors you're talking about, right? These are the Davis factors you're
Yes.
talking about? I only remember like amenability. What else?
These are the 5 factors.
What are the 5?
They've
What
been
are they?
around for a long time to
Yeah.
determine where the appropriate jurisdiction is.
Can you remind us what they are again?
Yeah, I have
All right,
it
we're
here
looking it
somewhere.
up, but here it is. All right, got it. Age of the child,
The age of the
mental-
child,
yeah.
the child's physical and mental condition,
Yeah.
the child's amenability to treatment in any institution, facility, or programs available to delinquents, the nature of the offense, and public safety. Those are the 5 factors that are taken into account, either a transfer back to the juvenile court or a waiver up to the adult court. Why do them again?
Thank you. There are 13 factors. As you go down those 13 factors, do you have those in front of you, right?
I do, yes.
And then you compare those to the 5 factors. Are there any of these 13 factors that you're saying, well, no, this, if I'm in court and you brought this up, that's not one of the 5 factors? Which of those 13, as you just go down them? I mean, obviously, the age of the minor at the time of the offense, that'd be admissible, right?
Yeah.
What about the capacity of the minor for rehabilitation?
Child, The child's amenability to treatment in any institution or facility, that's one of the things that's already
So
provided for.
that's a current factor. The
Yes.
minor's family and community environment? That's not a factor, is it?
Not in those words, no.
Okay. And then the ability to appreciate the risk and understand the consequences of their actions, is that?
That's not, I don't think that's in the 5 factors test.
Okay. And the intellectual capacity of the minor, I guess that would come out in the evaluation? There could be an evaluation order, that could be in there, right?
It's been a long time since I've read a report from the Department of Juvenile Services. Obviously, they apply those 5 factors, and they may make comments with regards to their reasons why, and it possibly could touch on other issues as well.
All right, I'm not going to pull you through all these, but it'd be interesting if for you all were to comment later which of these factors are already considered and which ones would not be considered. I'd be interested to know that.
Well, let's put it this way. What I think what we're getting at least what I'm trying to say, is that there's been a fairly comprehensive evaluation of which courts should have jurisdiction, whether we use the 5 factors test that's currently in existence or what's contained in the bill. I think the decision has been made based upon sufficient information, given the factors that have to be considered.
Okay, thank you.
Thank you.
All right, with that, that'll conclude the hearing for Senate Bill 769. We'll now move on to Senator Lee with Senate Bill 886. Senator Lee.
Mr. Chairman, can I have my panelists come up right now? Okay, thanks. Let's sit over there. How are you doing? Okay, this is, hold it, wrong one. Look at this. Colleagues, this is SB 886. Includes language modeled after a Pennsylvania law on car allocation, which has worked very efficiently with this particular state. This bill further aims to ensure that Maryland consumers have a wide and fair distribution of incentives, rebates, and cars themselves. Affiliates of a manufacturer, distributor, or factory branch that offers or advertises any consumer rebates, dealer incentives, price or interest rate reductions, or finance terms must make those incentives available to all dealers and all purchasers of vehicles of the same line make. The bill protects against discrimination for using your own financing and to ensure fairness in distribution to dealerships so consumers are less likely to be inconvenienced. Currently, incentive may only be available to those who finance with what they call captive financing arm of car manufacturers, which are not available to other car buyers. This practice is not fair because it allows for discrimination in things like prices and benefits based on the demands of the car company's financing scheme. Consumers are often feel pressure from certain dealers to add services and fees to the loan, or what they call loan packing, which only adds to thousands of dollars to the costs over the life of the vehicle with really little value. Consumer advocates often recommend car shoppers to arrange financing outside the dealer network, but those who choose to do so shouldn't face those higher prices. The cost of the vehicle should be separate from the financing option to allow more freedom to shop for financing that you prefer. To allow otherwise seems to be deceptive trade practice. It should be against public policy to the extent, and this, our General Assembly, and this intricate balances between dealers and manufacturers. The consumers should not be forgotten in this discussion either, and we are pleased to have the support of the Consumer Protection Division of the Attorney General's Office supporting this bill. We find ourselves in the middle of these groups because we must try to keep a balance of the distribution of power when it comes to policy decision affecting all Marylanders. You look at Section 15-207H of the Transportation Article already requires that manufacturers offer incentive and rebates through all their dealers of any line make and puts the burden of proof on the manufacturers. This bill applies that same principle and protection to consumers. For these reasons, we ask a favorable report on SB 886. I'll turn it over to my distinguished panelists. Go ahead.
Thank you, Senator Smith and Senator Lee and Chairman Smith. My name is Franz Schneiderman with Consumer Auto. We work for safety, fairness, and transparency for Maryland car buyers and drivers. We support this bill because it's really an important way to make rebates and incentives more widely and fairly available to consumers, and also make car supplies more fairly available to consumers. Under current rules, if you finance your car through these captive financing arms that the manufacturers maintain, you might get rebates and incentives that you won't get if you finance through your local credit union or CQ or Navy Federal or some other institution. That exposes people to possible discrimination from the manufacturers and from the dealers about whether you qualify for their special financing, and means that people who finance in other ways in effect pay more for their loans. We don't think that's fair. Now, these captive financing arms are profit centers for the manufacturers and for some dealers, but they're often a problem for consumers because, as Senator Lee explained, very often by financing through the dealers, you're exposed to all kinds of pressure from the dealership to add all kinds of services like extended warranties and window etching and other things that add thousands of dollars to the cost of the car, but really are very little value to consumers. The Wall Street Journal on Tuesday published an article about how that practice is intensifying in the current car market, and car dealers and car manufacturers are working harder to push people to finance through these captive financing firms. Senator Lee said the current law already requires that rebates and incentives be offered through every dealer in the state on a fair basis. This bill really just extends the same principle to consumers by requiring dealers to offer those rebates on a fair basis. It also just makes clear that everybody has access, that dealers all have access to a fair supply of cars on a fair and transparent basis that the manufacturers can explain to their dealers, and that also obviously gives consumers access to a better selection of cars. Thank you, and we'd appreciate a favorable report on the bill.
Thank you, Mr. Chairman. Thank you, Senators, for being here after a long day. My name is Rob Smith. I'm with the Fitzgerald Automotive family and been with them for a very long time, and I'm the bad guy, the boogeyman that sells cars. I've been doing that since I was 19. It's an honor to be here to represent Jack, and you'll hear from Mr. Diversey. He thinks that Jack's the only guy in business around here. But Jack is older and wiser than me, and he says I got to get past St. Peter, so it's about doing the right thing, and that's why I'm here. This bill is very simple. It's just adding the word affiliate, saying the captive finance company, if they offer a rebate, it really should be offered to anybody based on the car that they buy. It's like I said, very simple. So I have a son that's a Marine. Sometimes he may not have qualified at one point to get through that captive finance company, but Navy Fed loves their men and they take care of their Marines. So he would have been able to get that rebate, if this law was in place. And the second part comes right out of Pennsylvania law. It's about fair and reasonable distribution of vehicles. I like in this time when we have such a short supply that we're in a NASCAR race and we should all be on a yellow flag. We should all be reduced equally. We don't know if we are or not, and this just says it needs to be fair and reasonable, and the burden of proof is on you guys at the manufacturer level to make sure that it's fair and reasonable because it's your system. It's not prescriptive. And like I said, it's already in the Pennsylvania statute. I'm here to answer questions, and with that, I appreciate a favorable report. Thank you.
Good afternoon, Mr. Chair, members of the committee. Alex Shaw with Compass Government Relations, here today to speak in favor of Senate Bill 886, and thank you to Senator Lee for all of her work on this bill. I think that the other panelists and the sponsor did a great job of explaining the bill, so I will be brief in the interest of time. I would just like to reiterate a couple of points that were discussed by the other panelists. First, we think that this is a good bill for consumers by just allowing them to take advantage of a rebate regardless of the financing that they choose. And then the second portion of the bill is really straightforward, as Rob just said. It just says that the manufacturer and distributor have to have a fair and reasonable process by which they distribute their vehicles. It does not tell them how to do that or how to run their business. It just says that it needs to be fair and it needs to be reasonable. And we think that that will allow dealers to better plan to run their businesses and consumers to have better access to the vehicle that suits their needs. So with that, I would request a favorable report on Senate Bill 886. Thank you.
All right, thank you very much. Seeing no questions from the committee, thank you. Thank you. All right, we'll next hear from Mr. Johansson and Mr. Kitzmiller.
Good afternoon. Mr. Chair, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchise new car dealers across the state of Maryland. I will try to be as brief as possible. We're here today in support of the vehicle allocation section of this bill. As been previously described, it does come from Pennsylvania. I had a long conversation with the Pennsylvania Dealer Association this morning. It's worked very well. We are in this market facing the shortest vehicle inventory we've had since World War II. Any of you that have been watching the news or going out to look for a car, we're at about 10–15% of our normal new vehicle inventory at this point. And unfortunately, it doesn't look like that's going to improve any time soon. So this is a very critical issue. And all this bill does is simply say they have to have a process, which they all do. It has to be fair and reasonable. If a dealer feels that it's not being applied to them correctly, the manufacturer simply has to respond in writing and justify their program. And so I don't think it puts an additional burden on the manufacturer. I was planning on stopping there, but the previous panel, the description of financing a car to dealership is just absolutely inaccurate. Dealer arranged financing is about 85% of the people who come to a dealership, new car dealership, end up using the financing provided by the dealer because it's cheaper and it works better for them. This incentive section is very unclear to me. I'm sure the manufacturers will raise their concerns, but I could not let it go by without saying that that's just not the way it works in a car dealership when you go to finance a vehicle. It's very simple. You walk in, if you've been to the Navy Federal Credit Union and their rate is 3% and the dealer can get you 2.5%, you're going to go with the 2.5%. If they can't, you're going to go with Navy Federal Credit Union. It's not that complicated, and it's certainly not as it was described by the previous panel. So with that, I'd be happy to answer any questions. Thank you.
Mr. Chairman, good afternoon, members of the committee. I'm Mike Johansson on behalf of the Washington Area New Auto Dealers Association, also in support of the legislation. The language on page 2 of the bill, subsection F, looks like kind of a big expansion. It's really just a small enhancement to the existing law, which is in the rest of this section, 15208, which simply says a manufacturer, distributor, or factory branch may not refuse to deliver new vehicles to a franchise dealer if they have them available and the dealer has a franchise. And basically says that those delivery and timelines must be reasonable. So that's the existing law in the state. The new language then simply says if a dealer believes he's not getting his fair share of vehicles, he has the right to request the information, tell me what allocation method you're using, and lastly, if there's a dispute, the dealer has the burden of persuasion to demonstrate that their reasonable method is in fact reasonable. The burden of persuasion is also a core component of the existing state law, and in many sections of the code, the manufacturer has the burden of persuasion, not the dealer. So we think it's a relatively small enhancement, and we do support it, and we're happy to answer any questions.
You've beat us into submission. All right. Cold bench. All right.
Thank you.
Thank you very much. All right, that completes the testimony for the proponents. We'll now switch to the opposition panel, and for that we have Mr. Taverzi and Mr. Kress.
Mr. Chairman, members of the committee, I'm Paul Taberzi. I'm an attorney from Baltimore. 2 years have flown by. It's an honor to be back before this committee, the Lawyers Committee. Not all of you are lawyers, but it's always a pleasure to appear before this committee. I'm honored to represent General Motors and have for many, many years, and we're in strong opposition to both parts of the bill. There are two parts of the bill. And as the gentleman pointed out, this is the annual Jack Fitzgerald bill with respect to Senator Lee. Mr. Fitzgerald is a very successful, financially strong dealer, very successful. He's got great lobbyists and lawyers. I sat here all afternoon and I admire your endurance. My dad was a policeman, and I heard some of the issues that you're dealing with, and you're dealing with them every day: juvenile justice, public safety, the interlock bill, very important bill. And I would submit to you, those are the kinds of things this committee should and has always dealt with. Not getting between a very wealthy, successful dealer who's well represented, who has a franchise agreement with General Motors and other manufacturers. He's asking you to step in between private parties who have contracts and pass legislation to protect primarily him. The second part of the bill, the allocation language, was supported by my brothers, Peter and Mike. But the top part, the incentive language, which they don't support, is something that Mr. Fitzgerald alone wants you to do. The current law on incentives, I'm looking at Senator Huff, I believe many years ago, some years ago, you had a bill on that which we worked out and agreed to compromise language, which is in current law. We weren't thrilled about it, but it was a fair compromise. It's worked. There's no reason to change that. Mr. Fitzgerald wants you to go further and change that. Please don't. Now, we would respectfully oppose all the bill. The burden of proof language, as a lawyer and as a matter of due process, why should you change the burden of proof and put that on us? Again, no reason for you to get into this. Let the parties deal with it themselves. It's an honor and a pleasure to be here again. Thank you, Mr. Chairman and members of the committee.
Thank you, Mr. Chairman, members of the committee. Bill Kress here today on behalf of the Alliance for Automotive Innovation. We represent about 99% of the automobile manufacturers worldwide. We are in opposition to the bill. I want to ask the committee to take a look at the language on page 2, lines 1 through 4. This significant bill could adversely impact consumers, and I just want to make sure you understand how this operates with this language. So what this language says is we have to offer any incentive, which is a current law. The new language says to all purchasers of vehicles. And the way we interpret that language is that if we're offering an incentive to, let's say, somebody in the military or a first responder or a college graduate, we have to offer that incentive to all customers. And so these narrowly drawn incentives would go away. They are based upon a budget the manufacturer sets. And with this language, which would happen is the manufacturers would pull it. It would be one incentive for every customer. And I would think that the dealers would be very concerned about that. Maryland being a small state, people would shop across the border. So we're very concerned about that. With respect to the financing issue, this bill says if the finance company, the captive of the manufacturers, offers some incentive, we have to give that incentive to the consumer, even if they go with somebody else. So if you're going with with the credit union, we still have to give you that incentive. So why the manufacturer would do that is beyond me, because they would ultimately lose money on the deal. There's always some profit built in, even when they're offering that financing. So at the end of the day, the first section of the bill really doesn't make any sense to us. With respect to the second section, it's less objectionable, but we do have issues with the burden of proof. Thank you, Mr. Chairman.
All right, questions from the committee? Seeing none, thank you both very much. Good to see you both in person.
Great to be here.
All right. All right. With that, that'll conclude our hearings for the day. I'm sorry? We did that. We moved it up. We know. So more good news. More good news. So we will not vote tomorrow morning, but we will be voting a lot next week. So no voting tomorrow morning. Voting at least 3 times next week. So, all right. There you go.